Boom. Hey, folks, how's everyone doing? I need to fix this. So, yeah, I've been having no end of technical problems thanks to Logitech. Um, so, yeah, I was having some technical issues with my mouse, and one of the steps it had for, there we go. One of the steps it had for troubleshooting was install our proprietary thing. So I was like, okay, let's do that. And then it messed with all of my settings, and now I'm trying to unmangle everything. So that's its own headache. I need brighter colors. Sorry. I am apparently blended into the wall. Michelle says, "I'm not against guns, but your love of guns is odd." I enjoy target shooting. I enjoy firearm law, and yeah, firearm law is kind of a thing there. So, what is it? We got a whole bunch of stuff to talk about today, and so I guess let's sort of go through some of the topics here. I saw somebody was saying, "What is Proven Industries about?" Well, Proven Industries is they're a company. They make locks. That's what they do, and the problem is that the locks they make are subject to, or at least one of the locks they make is subject to a shimming attack. So what a shimming attack means is that you get a thin piece of material and you can sort of wedge it in there and sort of force the little locking bit down, and then it slides open. Now, the problem additionally is that they did a video, Proven Industries did a video where they basically said, look at our lock, it is super secure. Our lock is invulnerable and cannot get through, like nobody can get through anything. And, you know, it's like it bounces sledgehammers, it bounces crowbars, it bounces all sorts of things. And then somebody in the comments said, hey, I want to see Trevor McNally take a poke at this. And then, so you might be saying, what's a McNally? Well, Trevor McNally is a guy who picks locks for a living. It's what he does. He's on YouTube. He has a company. All of this stuff, like he does lock picking. That is his thing. And their response was, well, he's not going to take a try at our locks because he only goes after the easy ones, which is definitely a call out, right? Because they're basically saying this guy who picks locks for a living only goes after easy locks. Like he would never go after a hard lock, which, yeah, I mean, it's a big deal, right? And his response to this is pretty like severe on this, which is that he goes and he does a video, and the video is him him kicking his legs, him drinking a juice box, him pointing out that they called him out. And like he actually puts up the thing where they called him out, and then he shims the lock open with a pop can. So what does Proven do? Proven turns around and sues him. They bring a lawsuit against him. They allege defamation. They allege copyright infringement because they're saying you can't use our videos for our videos to mock us. They allege all the things, right? So they take exactly the wrong approach. Now, since then, they have dropped their case. But now they're getting sued by Packlock. And one of the things that Packlock did is Packlock is alleging perjury in the Proven Industries versus Trevor McNally case. And so we're going to cover their response to that perjury allegation, because that is a whole thing. And this is the other thing. Lol, I'm sure he would enjoy an unpickable lock. The thing is that if you can make an unpickable lock, right, then you actually, like, you will get shout outs and recognition from lock picking everybody, right? You will get recognition from that. They will be like, oh, that's really awesome. The other thing is this. Weren't they basically defaming him by accusing him of only picking easy locks? Kind of, yes. And I actually think that's a really big problem, because they actually opened themselves up for a countersuit in a really big way. So I've got several videos about that. We'll talk about that one kind of, I guess, as a bit of a palate cleanser. The main things I want to talk about here, there's a few things I really also want to get through. And one of them is really long, and the other two are mildly long. And so let's talk about sort of what is on the agenda. So we've got a couple of cases involving the SIG P320. Now, if you don't know what the P320 is, the P320 is a gun. And the problem is that it's not a very good gun. It is a gun that has been credibly accused of going off when the trigger is not pulled. And so this is a problem in a gun, because while you want a gun to go off when the trigger is pulled, you definitely do not want it to go off when the trigger is not pulled. That is a big party foul. Now, SIG put out a statement that is a big issue, but since then there has been an issue of a credible an issue of a person saying, well, this gun went off and killed a military member. There's also been somebody who did a video showing the gun going off when the trigger wasn't pulled. So all of this, now SIG is being sued by a guy, Officer Richard Fernandez Jr., who says that his SIG P320 went off when he didn't pull the trigger and shot him and caused him some pretty serious injuries. So we'll cover that case as well. We're also going to cover SIG themselves are suing. SIG themselves are suing. And this, I think, is some tremendous courage, we'll say. Tremendous courage on the part of SIG. And the reason why I say it's tremendous courage is that SIG is suing the Washington State Criminal Justice Training Commission because Washington State decided to ban the P320 from their properties. So Washington State Criminal Justice Training Commission does police training. They train police officers in how to use firearms. And they've said the P320 is too dangerous, and therefore we are going to ban it from our premises. And SIG is like, nuh-uh, you can't do that. I am just like, huh, That is a bold move. That's a bold move that couldn't possibly explode in their face. Spoiler alert, I think that they might be Streisanding affecting themselves in a big, big way. But we're also going to talk at length, and I think we're going to cover one of the SIG cases first before we get to the big, long case. And the reason why we're going to do that is because the big, long case is a sex assault case. So, fair warning, I will not be reading every line of text on the decision, because there will be some things that I will skip over for YouTube reasons, right? There's a lot of stuff that YouTube doesn't want discussed directly and will punish me if I do. So we're going to skip over some of that. And, but fair warning, it might be something that might cause some trauma to folks. It might, so if this is not the kind of case you want to hear a discussion of, then you're going to want to skip over that case. And it's 91 pages long. The reason why I want to cover this one in detail is because this one has received not just national attention, but also international attention. And it is a big deal. So what happens in a very broad sense is that 5 hockey players were celebrating their win of, I think it was the World Juniors. And so they win. And then they're celebrating, and they go to a hotel, and they're having some drinks. And they meet a young woman. And this young woman sort of joins them, and sexual activity occurs between her and the 5 guys. And then a civil claim is filed later alleging a sexual assault. As a result of that civil claim, they settle for an undisclosed amount, but it is reported to be about $3.5 million. And then that got national attention, and because it got national attention, they reopened the criminal case. And when they reopened the criminal case, they decided to lay charges. Those charges resulted in a trial. That trial was long. That trial was very difficult for all concerned. We'll talk a little bit about the difficulties of long trials and the difficulties involved in SA trials. So, yeah. The complainant was cross-examined for, I believe it was 9 days. 9 days of cross-examination. I just want to say, I don't know how I would tolerate 9 days of cross-examination, but that is part of what she went through. And ultimately, the court acquits all 5 of them. And so we'll talk about it, because I actually, I think that there's a lot to be gotten out of this from, we can talk about how these kinds of trials progress. We can talk about the standard of proof, the standard of evidence, and we can talk about how the media spins and misleads some of these things, because some of the coverage on this has been pretty disgusting. So were you a fan of the remold, the Rumpole of the Bailey? Remold? I haven't seen a remold. Do they have a Queen's Counsel and King's Counsel barristers in Canada? They do. And Valerie, no judgment if you're out, but we're going to cover one of the gun cases first. So, yeah. Now, people are saying, how could you get 9 days? Part of the reason why they get 9 days is because every accused is represented by counsel. And every accused is entitled, like, to have their counsel cross-examine the person, right? So they may want to go over different things and so forth. No, she's the complainant. She's the complainant on this one, not the defendant. So that might have been a misspeak. I don't know. Sometimes I mangle words. Complainant. The reason why complainant is used in Canada is what complainant means is just basically the person who brought the complaint. And it's used because that way it avoids any presumption of guilt. Because if you say the victim, that presumes victimhood and it presumes guilt, right? So in Canada, you typically say, yeah. And can each lawyer go over the same thing that's already been talked about? To a certain extent, yes. So to a certain extent, yes. Now, there was also video evidence. There was all sorts of things there. All right. So now that I've given you guys sort of a signpost of where we're going, I will also set up a goal. We have some hot sauces I haven't tried yet, so we'll start those for our goals here. All right. I picked up hot sauces while I was in Vancouver, and yeah. So the other thing I'm just going to note here is, guys, we are going to be civil to each other in the chat, and we are also going to be civil to the complainant and to all of the people involved. I get that you may have feelings about her or it or the guys. Let's try to keep them civil. Let's try to avoid stereotypes. Let's try to avoid all of this stuff, because these things are complicated. These things are difficult. And quite frankly, the human experience doesn't really reduce down to easy stereotypes and easy sound bites. And so that's an important thing to consider in this case. Let's, yeah. I also just say, please, whatever you do, don't fight with each other, right? I don't want to see you guys throwing shit at each other. You can disagree about things. Disagreement is fine, but let's not throw shit at each other. The other thing I'm going to note, I guess we'll start with this hockey case, because I've sort of been going on. We haven't started the hockey player case, and the hockey player case is 91 pages. So it's going to be lengthy. It's going to be a long time. So the other thing I'm going to note is that some of these accused people had, actually, I think all of them, it looks like, had at least one female lawyer. And there have been comments made online about the appropriateness of women defending people who have been accused of SA and so forth. And I just want to note that I condemn that shit in the most strict and harsh language. And the reason why is because, as a lawyer, any lawyer, you do not, you represent a client, but that doesn't mean you agree with the client, because everybody deserves representation. Whether they're good, whether they're bad, whether they're ugly, everybody deserves representation. And I can tell you, some of the best lawyers that I can think of in Canada, like some of the top names in the legal profession, are women. And they are very, very good at their jobs. If you ask me who's the best lawyer in Edmonton, I am certainly not going to say myself. I would love to be able to say myself. I would also be completely lying. I am not the best lawyer in Edmonton. I would probably say Mona Duckett is the best lawyer in Edmonton. And Mona Duckett is amazing. She is like just fantastic to watch. Like when you watch her in trial, it is. And so if I was charged with a serious offense, regardless of the offense, I would probably be calling Mona Duckett, right? And that's just it, right? It's it to me is offensive to say that like we should reserve this area of law to be only an area of law that is available to men. Because basically what that is basically if you say that women should not take these cases, then what you're saying is basically that this drinking fountain is for the men only. And I just want to also point out that these kinds of files tend to be very lucrative. And you might be saying, what do you mean lucrative? Well, it is probably no secret that most criminal files don't have a lot of money on them. Most criminal files involve people who like stole a bottle of booze from the liquor store because they don't have the money for a bottle of booze. And so, whereas this is one of the kinds of charges that gets laid against people who are wealthy and people who are poor. And so there are a lot of people who have money who get charged with sexual offenses. And so what that means is that if you want to take on files that have money, then you're probably looking at a bunch of the sex assault offenses, right? And it's just an unfortunate truth, right? You're never going to make huge money representing shoplifters. So if women are barred from taking on this kind of work, if we say women can't do this kind of work, or they shouldn't do this kind of work, or it's immoral for them to do this kind of work, then basically what we're saying is that female lawyers practicing in criminal law should make less money, should get less trial practice, because you get trial practice, you get cross-examination practice, you get all of these things. And they should be worth less, not worthless, but worth less to their firms. Because if I am looking to, to represent, or if I'm, let's say I'm starting a firm, and let's say I'm starting a firm where, I'm doing work for money, right? Which is the usual way firms work. And I'm looking to hire a new junior associate, right? I'm just looking to hire a young lawyer who I expect will stay with the firm and work for the firm and all of those things, right? Wouldn't I want to hire the lawyer who can take the files that bring in money, as opposed to the lawyer who can't? So, yeah, I mean, this notion that women have these special rules that male lawyers don't, to me is absolutely abhorrent. And, if you ask me to name, I'm not going to do a top 5, but I have like a top 5 in my head. If you ask me to do a top 5 of the lawyers in Edmonton, at least 3 of them are women. At least. It's 3 or 4, and I'm not certain on that. The other thing that we don't want to talk about, but is true, is that sometimes sexual offenses are committed by women. And so and sometimes sexual offenses are committed by women against women. And, by men against men too, right? So how does that work, right? What happens if how do we assign the gender of who gets to represent who? There was just a case that made the news. There was a 6.5-year sentence for a very egregious sexual assault of a trans woman. How, what gender do we need to decide, who gets to represent the? All of this stuff makes no sense to me whatsoever. Quite frankly, the whole idea is bullshit. And any article you read that suggests that women should not be able to represent, people accused of this or whatever, it's reprehensible. Yeah, just absolutely. So I condemn in the strongest terms anybody who says, that these lawyers behaved in any way improperly in taking this file. All right. Now, I guess we got 91 pages to go, so let's dive in. Let me just pull this up. I'm having some problems with my screen sharing, so come on, do the thing. I don't know why, but my computer has been causing me all manner of trouble here. Which is the one we want? And there we go. All right. Now, I will note the other way to get yourself permanently banned from my channel. I don't ban a lot of people, but there is a great way to get permanently banned from my channel, and I will tell you what it is if you want to never be here again. So you will note that this is that the complainant in this case is described as EM. And that is because there's a publication ban on the name of the complainant. If you happen to know the name of the complainant, do not post it in chat. Because if you do post it in chat, you will be banned forever. And I will not be putting up with any hey, I want to get unbanned. I made a mistake. It's nah, that is not how we roll here. So do not, if you know the name, do not know the, do not post the name. But there are some people, and this is a fair commentary. There are notes here that the accused have all had their name published, right? The accused have all had their name put out in public. And I would redact it, but yeah. Lord Byron, no problem. I don't know if I think I missed one, but I would redact it, except their names are well known, right? So yeah. I do see an argument for maybe we should keep their names secret as well. But the thing is people would have figured it out because they all got suspended from hockey teams and it would have been really obvious. But yeah. All right. So let's dive in here and we're going to talk about things as we go. So this is going to be very, very lengthy. What are the other ban-worthy things? Persistent trolling, like not getting the hint after many, many times and just being disruptive. There's a few other things, but yeah. So introduction. On June 18th, members of the 2018 Championship Canadian World Junior Hockey Team were gathered in London, Ontario to celebrate their victory in the World Junior Hockey Tournament earlier that year. What occurred during the early morning hours of June 19th, 2018 between the accused and the complainant, EM, forms the subject matter of the charges of SA before the court. The team was staying together at the Delta Armories Hotel, the Delta Hotel, or the hotel located at 325 Dundas Street in London, Ontario. The formal events began on June 18th with a ring ceremony where each member of the team received their championship ring, which was followed by a gala dinner and a golf tournament scheduled for the following day. I don't know why they have a golf tournament, but like, aren't they hockey players? Why do they have a golf tournament? But okay. Following the ring ceremony at the Delta Hotel, the team photograph filed as Exhibit 17 was taken. Later in the evening, a gala dinner was held where alcohol was served both before and during the dinner. Very, very common. Yeah, sorry, I just kind of got on a roll. Yeah, we can do the saran wrap. I see somebody saying no saran wrap. We'll do the saran wrap. Maybe I'll put up a banner here as well. There we go. There. All right. So, after dinner, members of the team, including all of the accused, returned to the Delta Hotel, changed from their suits into casual clothes, and attended Jack's Bar on Richmond Row in downtown London. The team arrived at the bar between 11:20 and 11:40 p.m. It was at Jack's Bar that the complainant, EM, met the accused and other members of the Canadian World Junior Hockey Team. She eventually left Jack's Bar with Michael and returned to his room at the Delta Hotel, where they engaged in consensual sexual activity. So that part is not alleged to be like anything untoward, right? Is that part. It's after that that things sort of go off the rails. So EM alleges that after the consensual sexual activity concluded, she was SA'd by each of the accused, including Michael there. The complainant testified that she did not consent to the activity that took place, and she felt that she did not have a choice about whether to engage in the group sexual activity due to intoxication or fear, or a combination of both. The defense maintains that EM was an active and willing participant in the sexual activity that occurred with each of the accused in room 209, and in fact initiated much of it. Now, I'm just going to talk a little bit about one of the sort of ways people reason through things, and that is not good reasoning. And so one of the reasoning that they apply is basically this sexual activity was weird, and therefore she couldn't possibly have consented to it. And that is not good reasoning, because people get up to all sorts of crazy stuff. I mean, the range of activities that people participate in consensually is huge, right? And, this is not my cup of tea, but there are people who engage in, group activities. There are people who engage in, partner swapping. There's people who engage in all sorts of things. And I think that there was one person who studied things who basically said that if it is possible to do something, then somebody is doing it right now. And if it's not possible to do something, then somebody has still tried it, right? Yes, I saw somebody, I missed the chat. I tried to click in the chat, but somebody mentioned that, if you are working as an ER doctor, that at some point, and it won't be long, like this will be a regular thing, you'll have somebody coming into the, into the ER going, hey, I fell on it. And I have become very unfocused. Why am I unfocused? Manual focus. There we go. Somebody will come into the ER and say, I fell on it. And that's how it ended up, south of the equator. And spoiler alert, they didn't fall on it, right? if you are ever if you're ever going to the hospital, this is like a, if you're ever going to the hospital with a thing that is lodged in places and they ask, how did this happen? They already know that it happened in some sort of like sexual hanky-panky, right? There is no excuse that you can use to get out of the embarrassment. The question that they are asking, the reason why they're asking is they really want to know one thing. What they want to know is, was it consensual? Because really all they're asking is, hey, this shampoo bottle that ended up there, did, we don't believe that you fell in the shower. We just want to know, did somebody put it up there without your permission, or did you put it up there, or did you have permission, or did somebody put it up there with their permission, and all of those things, right? So, yeah, the attention deficit, sort of warning on all of this is basically that just because something is something that you wouldn't agree to doesn't mean that it's impossible that somebody could have agreed to it. This becomes a problem for anybody who engages in, anybody who engages in things such as, BDSM, etc., right? So the reason why I say all of this is that some people have basically said there's no way she could have consented to this. And I go, that's actually stereotypical reasoning that is not allowed. So carrying on here. So the events that took place in room 209 at the Delta Hotel in the early morning hours of June 19th, 2018, were the subject matter of a London police investigation and an investigation by Hockey Canada, the governing body of the World Junior Hockey Team. Initially, those investigations resulted in no criminal charges being laid. Those events were also the subject matter of a civil claim filed by the complainant in the Superior Court of Justice that settled for an undisclosed amount of money without the knowledge or the involvement of the accused in this case, i.e. the accused never settled. The hockey thing settled, right? The hockey organization settled. Once the settlement of the civil claim filed by EM was made public and garnered national attention, the London Police Service reopened their investigation. There was a renewed investigation by Hockey Canada. There was also a mention of the Standing Committee on Canadian Heritage ordered by the House of Commons to study Hockey Canada's involvement in alleged sexual assaults, which included these specific events. Ultimately, the criminal charges that are contained in this indictment were laid. So what this should tell you, this is always a warning sign for a bad decision, because this case started getting national attention, right? National attention, and there was a tremendous amount of pressure to bring this case. The lengthy and contorted history of this case, including the multiple investigations by different agencies, including the civil action and settlement, has led to multiple, often conflicting statements from the complainant, the defendants, and witnesses. With 5 accused and that barrage of evidence, I can say that counsel conducted the trial efficiently and that the time spent, particularly in the cross-examination of EM, was entirely appropriate. So what the court is saying here is the court is saying, listen, the counsel behaved appropriately. Settling admits guilt, but none of these accused settled. These accused didn't even know about the settlement. It was like Hockey Canada or somebody else who settled. So, yeah. Much has been made in this case about the concept of consent. This case, on its facts, does not raise issues of the reformulation of the legal concept of consent. What they mean there is basically that the court is just saying, we're applying the law that exists. We're applying the standard law of consent that exists everywhere, right? In this case, I have found actual consent not vitiated by fear. What does it mean for consent to be vitiated? Consent, when it's vitiated, is not valid consent, right? When it's vitiated, the consent doesn't count for anything. It doesn't mean anything. It doesn't, anything there. So let's consider some examples of things that can vitiate consent. One of the things that can vitiate consent is age. Like, there is no circumstance where that 11-year-old can consent. Like, it's not a thing, right? Vitiating consent can be done through fraud. Let's say you've got a twin brother and you pretend to be your twin brother in order to sleep with your twin brother's girlfriend. Her apparent consent is not actually consent because it is vitiated by the fraud of you pretending to be that other person. Consent might be vitiated by if the consent was obtained through coercion or fear. If you're sitting there and hey, she's agreeing to do various things and she's doing it because you have a shotgun in your hand, well, that's not valid consent, right? That consent is not, valid. So that's the idea of vitiation of consent. So I do not find the evidence of EM to be either credible or reliable. In my lengthy reasons set out below, I will explain why I reached those conclusions. So when she says hey, when the judge says, I don't find their evidence to be credible or reliable, saying it's a bad witness. Yeah. It's Always Sunny in Philadelphia because of the implications is an example of vitiating consent. Yes. That whole skit is in fact about vitiating consent. So yeah. So as I must, I have applied the legal analysis directed by RVW, so this is the Queen as it was at the time, or the King, and WD. Now, WD is a critical case. It is one of the cases, if you had to ask which case is most cited in criminal law, then there is a very real possibility that the correct answer is WD. WD may well be the most cited case in criminal law. If you don't know WD, then you don't know criminal law at all. Now, WD is initialized because WD is, there's a publication ban on that one as well. So what WD says is it addresses and no, it's not WD-40. It addresses the standard for how, or the analysis for how courts should go through it. And it's an informal 3-step process. The informal process is basically this, that there be 3 steps in the analysis. Now, the court specifically says no rigid application of the 3-step analysis is necessary. It's not like a magic formula where you have to go through everything, in order, but this has to be sort of the way you think about things. And so step 1 of WD is that you have to decide, is there enough evidence to convict the accused? Just on in a case of a he said, she said case, on the complainant's own evidence, is there enough to convict the accused? And if that's not the case, if it's not the case that there's enough evidence just on the crown, on the sort of case at bar, then you have to acquit, right? And then sort of the next step is, well, do you believe the accused? Assuming that the accused is providing a statement that is exculpatory. And if you believe the accused with their exculpatory statement, then you also have to acquit. And then the third consideration is, even if you don't believe the accused, does their evidence raise a reasonable doubt? And so, as an example of this case, I had a case that is it was a fraud case, and my client's argument, and my client testified, my client's argument was basically, I didn't understand, I didn't mean to fraud, I just didn't understand. Like, I just didn't know what was going on. And the judge says, listen, like the judge in the ruling said, listen, I don't believe the accused. I don't think the accused is being truthful. But because their story is possible, because I can't rule out their story, we have to acquit. So, yeah. What WD is intended to avoid is the an error that a lot of people make in analyzing evidence. And that error goes like this. The error that people make, and that the courts have specifically and repeatedly and so forth said you cannot make in deciding things, is that you've got one person says crime happened, and the other person says crime never happened. And that the court balances those and goes, well, I find this one more believable than the other one. It is not a case where you look at the two stories and decide which one is more believable. In fact, you have to look at the two sides, and you have to decide, is there proof beyond a reasonable doubt? Because if you get to more believable, if you start making decisions based on which side is more believable, then what you're looking at is not proof beyond a reasonable doubt. What you're looking at is instead, basically you've converted it to balance of probabilities, and you can't do that. We didn't hit the goal, so I'm starting the goal again. All right. So carrying on, let's bring this back up. So with respect to the charges before this court, having found that I cannot rely on the evidence of EM, and then considering the evidence in this trial as a whole, I conclude that the Crown cannot meet its onus on any of the counts before me, i.e. it basically fails on step one. So the evidence. The events at Jack's bar. EM did not know any of the accused before June 18th, 2018. That day, she worked at a retail store in London and made plans with some of her work colleagues to go out after work to Jack's bar to socialize, drink alcohol, and dance, as people do, right? I've seen some people, by the way, I have seen some really horrible discussion of this on both sides. And the fact that she was out at a bar drinking and dancing and so forth doesn't mean shit. After work, she went home and changed her clothes and got ready to go out. She testified that she consumed 2 cans of Mike's Hard Lemonade while she got ready, which made her feel more relaxed. She called an Uber and picked up a coworker, VH, and went to Jack's, arriving there between 11 and 11:20 p.m. Jack's bar is equipped with a video surveillance system with cameras that record most, though not all, of the events that occur both inside and outside of the bar. Both the Crown and defense introduced into evidence various video recordings from Jack's from June 18th and 19th, 2018. Those videos are recorded in 20-minute segments from different locations in the bar. The actual time is not shown on the recording, just the time period. For example, from 11 p.m. to 11:20 p.m. As soon as she arrived at Jack's, EM is observed on video going to the ATM machine, and then she and VH went to the bar and ordered shots. EM consumed 2 Jagerbomb shots, which contain Jagermeister liquor and Red Bull, and then she and VH went to the dance floor where their co-workers were. This is not a judgment of her, but her drink preferences and my drink preferences are very different drink preferences. She's like, I had 2 Mike's Hard Lemonade, and I'm like, yuck. And then I had 2 Jagerbomb shots, and I'm like, also yuck. So I'm just like, These are not my favorite things. After dancing for a brief time, she and VH attended the bar again, where Ian consumed another shot, this time a shot of tequila or vodka. She could not recall which. I like tequila sometimes, so yeah. EM testified that initially she was not feeling really comfortable. She was a little nervous, and the alcohol helped calm her nerves and helped her enjoy dancing a little bit more. I get that too. I feel like an idiot when I'm going out dancing. So yes. Do we have her age? I don't think we do. So the accused, together with other members of the team, are observed on video arriving at Jack's bar between 11:20 and 11:40 p.m. They were required to show identification to enter the bar, and Mr. Formenton, who was not 19 years old, was not permitted to enter. So one of them got turned around because he tried to go to the bar, and they're like, ID, please. And they're like, nope. Nope. According to EM, she was approached while on the dance floor by a man, and they started dancing a bit, and then he brought her over and introduced her to another man. There is no dispute that the first man that EM was dancing with was Brett Howden, who was also a member of the Canadian World Junior Hockey Team, and the man to whom she was introduced was Michael McLeod. After meeting Mr. McLeod, he and EM had a shot together at the bar. According to the complainant, she was already drunk a little bit at that point in time and does not recall any conversation with Mr. McLeod, although she recalls that she spent a lot of time with him at the bar. By the by, people get drunk at different rates. People get drunk. Some people get drunk faster. Some people get drunk slower. And yeah, so I wouldn't this is why I'm not doing the drinks counting thing, because it doesn't necessarily mean much here. And there's a footnote there, which is just that it's from the transcript. She learned during the evening that this group of men played hockey together, although she did not know at what level. Now, this is where I start being a little skeptical, because I find it very difficult to believe that these hockey players were not boasting nonstop about what happened. It's a group of young hockey players who've just won a championship. They're out trying to pick up women. I am gonna bet that they went out and that they were absolutely bragging about being winners, right? That is my first thing where reading this, I'm like, there is no way they could keep that to that they shut up about that. I'm sorry. It's just not how I think that was likely to have happened. According to EM, in addition to two Mike's Hard... Now, I'll note, that is of the least things there. According to EM, in addition to the two Mike's Hard Lemonades she consumed earlier in the evening, while she was at Jack's bar, she consumed a vodka soda, 1 beer, and 8 Jagerbomb shots. According to her evidence, this includes the shot of vodka or tequila. She testified in chief that other than the first few shots she purchased when she was with her friend, the rest of the drinks were bought for her either by Mr. McLeod or the rest of the group of his friends. She also described an older gentleman who was with the group who poured a shot into her mouth during the evening. In cross-examination by Mr. Brown, the complainant acknowledged that this was inaccurate when she was shown video footage of attending at the ATM machine to withdraw money, then purchasing her own drinks. Now, I will just note, not all inaccuracies are made equal. This is one of the things that you have to deal with when you're cross-examining a person, because just because you can show that somebody got something wrong doesn't mean that the court is going to be like, well, this person is not worth anything, right? Now, you can end up with situations like... you can end up in situations where the volume of inaccurate statements becomes excessive, or you can have situations where things are, where they're critical. You also get two separate issues here. The issue of reliability is basically not, is she honest, but is she testifying accurately? And that becomes a big deal when you start adding booze to the equation, right? Because once you have a few drinks, memory starts to get a little fuzzy, right? And that's not like a judgment of anybody or anything like that. It's just the way drinks work. They affect memory. The other thing is that, but you can also have issues of credibility, which is like, is this person actually testifying honestly? Or is this person being dishonest when they talk about what's going on? All right. Now, why is I don't know why, but I was sitting here dying of heat, and then I'm like, why is my air conditioner set to 25? Yeah. She doesn't remember whether she had vodka or tequila. That's a memory lapse because they taste way different. It's a memory lapse, but I can tell you that there is basically no chance that I would remember like 6 drinks in whether I had tequila or whatever else. Yeah, 25 Celsius. So it's set to what is 25 in freedom units? 25 Celsius in, I'm just trying to see. That is 77. So my AC was set to 77, which, is not actually cooling my room down at all. So I just set it to 20, which is 68 Fahrenheit. So, yeah, now I'm trying to set it to something that'll actually cool me off instead of, yeah. So I'm sitting here like sweating and going like, what the heck? All right. Furthermore, during her cross-examination, EM was shown a glass from Jack's used to make Jagerbomb shots. Mr. Brown demonstrated and the complainant agreed that the glass holds half an ounce of alcohol and not a full ounce. It was suggested that the complainant consumed less alcohol than she thought, that is 4 ounces of alcohol in the 8 Jagerbomb shots rather than 8 ounces based on the size of the glass. She agreed. I also just want to say, this bar sucks. Can you imagine you go into a bar and you're paying for an ounce of booze and you're getting a half ounce? I'm sorry, if I'm paying for an ounce, a 1 ounce shot, I want to get a 1 ounce shot, right? According to the complainant, at that point in her life, she was attending university and would go to bars usually once every weekend, but normally 4 coolers would be enough to make her feel drunk. Consuming this much alcohol was excessive for her. Okay. Wolf Chiara says, and how does that make her less credible? It doesn't make her less credible. It makes her less intoxicated, because one of the issues for intoxication is like, was she so intoxicated that she couldn't consent? And if she's had 4 ounces instead of 8 ounces, that's a big difference, right? So big difference. In cross-examination, EM agreed that a normal amount that she would drink on a night out at Jack's would be 6 to 8 drinks. She agreed that according to the video, after meeting Mr. McLeod, she purchased a shot for him. Once shown the video evidence, the complainant conceded that she purchased the Jagerbomb shots for herself, most of them before ever meeting the player or any of the players. She also acknowledged that she did not tell the police that she actually purchased a shot for Mr. McLeod. EM testified that she forgot about that because she was really drunk. Now, you might be saying, why is any of this relevant? Why is any of this, why is this anything that we care about? What would have been suggested is that they were specifically trying to get her drunk, right? And so it's very different if they're buying her booze and sort of constantly pouring booze down, her throat, versus if she just happened to drink a lot of booze, right? That's a different consideration. It's not the be all end all, but that's why they were asking this on cross. The complainant was shown a plastic glass from Jack's, which she agreed was like the glass from which she had consumed a beer that night. The bottom of the glass is marked 7 ounces, and she agreed that it was significantly smaller than regular beer glasses. This bar really sucks. This bar really sucks. This whole activity would have been illegal in the U.S. What is the drinking age there? 19. In the U.S., it's 21. 19 is the drinking age there. So, yeah. This bar with half-ounce shots and 7-ounce beers? Fuck this bar, I'm just going to say. EM described that she was feeling the effects of the alcohol as the night went on, and her inhibitions were lowered as she consumed more alcohol. According to her evidence in chief, she was less aware of her surroundings and felt her vision was a little blurry, and she was not feeling very aware. Okay, let's talk a little bit more about intoxication, because intoxication is one of the things that can vitiate consent. Consent is not valid when you are too intoxicated to consent. And you might be saying, wait, isn't that kind of a tautology? Yes, it is kind of a tautology that, if you're too intoxicated to consent, then your consent is not valid. But what does it mean? Because it doesn't mean just that you had some booze, right? Like, I just had a long sip of a gin soda. It's 7%. I am still legally able to consent to activities. I'm not inviting anything because, we're not doing that. But it is... there is a cutoff. And the cutoff is actually a lot further than most people think. You have to be pretty drunk before consent is vitiated. And the reason why is because otherwise, if just being drunk was enough to say that consent is not valid, then basically, like, we end up with a problem of, like, all of sexual activity that takes place between human beings becomes illegal. Because, quite frankly, most people go out and drink and, like, if you're talking about people going out at bars, most of them are getting drunk and having sex and so forth, right? So it's actually got to be fairly severe. And to give you an example of, like, fairly severe, you cannot legally drive, most likely. Like, the point of you cannot legally drive kicks in, at least in Canada, long before you cannot legally consent to sexual activity. Because if you... the standard for driving of being too intoxicated to drive, not just the numeric blood alcohol, but the too intoxicated, is the point where your driving is affected negatively, however slight, right? However slight. So, you can be fairly sloppy and still legally consent. But if you get somebody, the examples that really come up as sort of obviously not valid is, let's say you are so drunk that you don't really know where you are, right? That you are so drunk that you were just kind of sitting in a puddle, right? I don't drink like this anymore, but, like, I have been at a point where I'm just, like, so drunk that I'm sitting in a chair and I'm not unconscious. Like, I'm not passed out, because passed out is obviously not consent, but I'm just, like, I'm blitzed, right? And so if you're sitting there and you're just, like, completely blitzed and you cannot do anything without help, then you're probably, then it's too far, right? But, yeah. Spark plug, I will get to that one, and I'm trying to do research into it. I'm planning on doing that one because it is kind of messed up. But yes. So, this is important to remember, and I will note it is better, it is better to not push the line, right? It is better not to be anywhere near the line. But at the end of the day, most human activity is kind of messy. And so, yeah, just be aware of that. Also, both sides of the equation take some risk if there's intoxication. I should also note that this works. This works both ways. There are guys who get assaulted by women and also by men when they are, drunk off their butt. So, yeah. EM testified in chief that she remembered dancing with the group of men at the bar, but she felt uncomfortable because they were taking turns dancing with her, and she felt sandwiched in. They were passing her back and forth, and they circled around her. She testified that there was a lot of physical contact and grinding bodies against each other. She thought it was kind of odd that Mr. McLeod was okay with the way others were pulling her away to dance. She also described that some of the men moved her hand to touch their crotch area. The complainant testified that when this occurred, it felt a little off, but because she was drunk, she went along with it. She was trying to dance and have fun. I should also note that in Canada, the standard for sexual activity or for consent, is not going along with it. Going along with it is not the standard. So, as an example of something that would not be valid, validly communicated consent. Now, I should note here, consent is subjective. Whether consent exists or not is in the mind of the person who is consenting or not. But it's very difficult to overcome when they say, hey, I wasn't consenting, right? So what a lot of SA trials hinge around is a concept of honest but mistaken belief in consent, because not only does there have to be the offense in fact, but there also has to be the mens rea for the offense, right? The mens rea is the guilty mind. So when we're talking about the guilty mind there, not only does there have to be non-consent there, but there also has to be something some awareness of either that there wasn't consent or that they were reckless as to whether or not consent happened. But, as an example, let's say you go to, you're at a party, right? And there's a woman there and she's chatting with people and so forth. And you sit down next to her, you're chatting with her and, whatever else. And you reach your hand around her and she makes a face and she's not happy about it. But she doesn't say stop. And, then somebody goes and, moves their hand further on. And she makes an uncomfortable expression, but she never actually says stop. Well, the fact that she didn't say stop doesn't mean that she was saying go, right? And if you don't have something where she is saying, yes, I would like this, and that can be either verbal or it can be nonverbal, right? As an example of nonverbal activity, if you, how do I put this? Any way I can put this is going to be somewhat offensive, but for nonverbal expressions of consent, let's say somebody, if you say, "Can I kiss you?" to the person, and the person leans in and goes and makes the kiss face, leaning in to that, that's kind of a nonverbal indication of consent, right? They're clearly indicating that they are consenting to the kiss, because when you say, "Can I kiss you?" they lean in and do the, it's showing that they want to be kissed, right? This is an understanding of the fact that most human sexual activity is not done through like negotiated contracts, right? It is not something where you sit there and you're like, and keep in mind, there has to be consent for every stage of things, right? And for most people, consent of every stage of things is for, is going to be nonverbal, right? In the sense of, if you are getting down with somebody, you might, consent to take the next step is probably not going to be indicated as, please do X next, right? So all of this is complicated, but silence is not consent. Compliance is not consent. There has to be some sort of affirmative communication of consent. There has to be some sort of affirmative indication if you want to be able to rely on that indication later. The other thing I will note is that if you do have a contract, if you do have a contract, those contracts are not useful. You will sometimes see online, I have a whole video about this. You will sometimes see online, like, consent agreements. And these consent agreements are not in any way useful. Now, I should note, there's two kinds of agreements that you will see online. Agreement number one is people who are doing things for kink reasons, and that the whole contract thing is really just like a kink. That is like, nobody's expecting that counts for consent. They're just doing it because it makes, it makes their bits do bit things. But if you are doing things like, I am going to get her to sign a thing beforehand so that I can prove consent later, that is not useful, because consent has to be consent has to be at the time. So consent has to be like at the critical moment. You can't consent to something in advance. It has to be continuing consent. So, for example, let's say, Jane tells Bob, "Hey, I'm going to have sex with you on Tuesday. I want to have sex with you on Tuesday." And so Bob shows up on Tuesday and is like, "We sex now?" And Jane is like, "Don't feel like it." That "I will have sex with you on Tuesday" is not valid. Like, the instant she says "don't feel like it," then it's not there, right? And this is the other thing, is that consent has to be continuous. I've heard of women removing consent right in the middle of the act. Yes. And both men and women can revoke consent midway through. And your responsibility is to stop immediately, not in 5 minutes, not in 30 seconds. It is, you stop right away. Like, you stop right away. And you can end consent for any reason or no reason, right? You don't need a reason at all to stop consenting, right? Like, you can just say, "I don't feel like it anymore. Don't want it. No good," right? Like, let's give sort of an obvious example. Let's say guy is engaged in relations with a woman, and midway through, they're having sort of talk in the middle of this thing, and the guy says to his girlfriend, or we'll flip it around. We'll flip it around here, because the girl says to the guy, "Hey, You're even better at this than your brother. And so suddenly he's like, whoa, stop, timeout, I'm done. Right? What did you just say? We done here. She's got no right to demand that he continue if he is no longer feeling into it because of that comment. Right? Like, she has no right to say, like, she has no ability to say, keep going. That's, that's a hard no, right? So, yeah. Consent is tricky and complicated and so forth. And yes. And it's one of those, it is one of the most high stakes laws that we have at all. So, EM testified that over the course of the evening, she was attracted to Mr. McLeod and he seemed interested in her. She acknowledged kissing him. She agreed during cross-examination that she did not tell the police when she provided her first statement on June 22nd that she had kissed Mr. McLeod at the bar. She explained that she was not asked about it and she thought it was self-explanatory with the dancing and the interactions at the bar, but she did not purposely leave that out. She also agreed that she did not mention the kissing when she provided a statement to Hockey Canada on July 20th, 2022. So, stuff that she's leaving out there. The complainant was shown video recordings from Jack's bar. She did not recall dancing with Mr. McLeod and Mr. Howden together. She did not recall that Mr. Howden hit her butt as she walked away from the dance floor. According to her evidence, at that point in the night, she was feeling off balance as if it was taking a lot of effort to move around and stay upright. She felt her judgment was starting to be impaired at that point, like she was not really aware of what was going on. She recalled going to the bathroom and slipping or losing her balance and falling to the ground. Now, this is her evidence, which was not super accepted. Just be aware. In cross-examination, the complainant agreed that she told police in her initial statement that she was alone when she fell leaving the bathroom, but in a statement provided to Hockey Canada, she stated that Mr. McLeod was present when she walked out of the bathroom and fell. So further inconsistencies there. EM agreed that in her first statement to the police, she told them that the players separated her from her friends. She explained that she was not trying to imply that they kept her away from her friends when she said that. It was suggested to her that she made a choice to separate herself from her friends. She denied the suggestion. According to EM, she felt pressure to be with Mr. McLeod throughout the night. She described at one point trying to go to the bathroom to sneak away so she could go off on her own, but he insisted on staying close to her. He walked her to the bathroom and waited for her until she came back out. She said she accepted that she would go with him to the hotel. She described herself as a person who has a bit of a hard time saying no to people. EM described feeling okay about going to the hotel with Mr. McLeod, but she felt that if she was not drunk, she would not have done that. Note, the standard for vitiating consent is not, I wouldn't have done this sober. It's not, I wouldn't have done this if I was sober. It's, I couldn't make the decision. Now, I should also note, there is a range of sexual activity that is gross and that is not okay. And, that is not acceptable. Well, and I say not acceptable in the sense of like, we find it disgusting, but it's still legal. There's all sorts of things that we might find to be, not something we'd want to see like relatives do or whatever else, but that is still legal. And, we say, like, the law says that consent that is obtained through coercion is not legal. But coercion doesn't necessarily mean pressure, because people pressure each other all the time in ways that are legal. Coercion to be invalid has to be coercion such that it would be like abusive. But let's say, for example, let's say that you've got something where let's say you've got, and, I'm like, how do I tiptoe through some of the examples to explain things without like being offensive? Because, yeah, let's say, husband and wife is feeling unloved and uncared for and so forth. And she goes, hey, husband, you haven't like been intimate with me in a while. Please, can we do that tonight? And the guy is like, I don't feel like it. I'm tired. It's been a hard day at work. She might pressure the guy and say, you would do this if you love me and so forth. But that is probably not coercion. Now, if she says something like, do it or I kill your dog, then we're probably talking about coercion, right? If she says, do it or I stab you in the eyeballs, then you'd be talking about coercion, right? All of these things, it's a different kind of scenario, right? The other thing is women in general, just as a bit of advice. Keep in mind that the average bartender and so forth would really, really like to feel like a hero, and that they will absolutely feel like a hero if they get to, save you from a bad scene. And yes, this is the thing. If you really love me, you'll boink me is still a gross thing to say. It is, but it's probably not illegal, right? It is probably not a crime at that point. Now, let's, if you've got a guy who is being creepy, if you tell the bartender, I need out, I need help, you're probably going to get help in a real hurry. Like, it is a thing, right? So, just be aware of that. Sometimes bars are doing better with like different ways to signal that and so forth. But, yeah, as a general rule, like, yeah. The other thing is that, the problem with that is that people sort of know what that means usually. Sometimes different bars will have like a thing where it's like a specific shot is for asking for help. And the bars that are really considering that well do that for both men and women. And sometimes they'll do it where they have like different sort of help me shots for the men and the women in the different bathrooms. But, yeah, it's the thing is, there's different sort of signals that some bars will set up. And if I was running a bar, I would absolutely, I'd absolutely have that sort of thing. But I'd also have things, quite honestly. If I was running a bar, I would put in the bathroom a button, and the button on like inside the bathroom would be, I am in the bathroom and I need help. And it would just be like, if you are like hiding in the bathroom waiting because there's a guy out there, you can just hit the button and like, bouncers will go help. So, yeah. All right. Yeah. And we're covering this one because it is getting national attention and because it is an important topic. So, in cross-examination, EM agreed that in her July 20th statement to Hockey Canada about these events, she was trying to convey that she felt that she could not get away from Mr. McLeod. She explained that she did not write that statement fully and that what she said about falling outside of the bathroom in the initial statement provided to police was accurate, and this was an error. Further, in cross-examination, EM acknowledged that if she wanted to leave Mr. McLeod, she had lots of options to do so, but it was hard to think with a lot of alcohol in her system, and she has a hard time saying no to others. The complainant was shown video from Jack's, which showed her greeting and speaking several times to a man working as a bouncer or security for Jack's bar. EM advised that she knew this man from high school and that they had been friends in high school. I'm just going to note, if you are good buddies with the bouncer, you could probably get the bouncer to to speak up and help you out. EM agreed in cross-examination that she did not mention her interactions with the bouncer in any of the statements to the police or to the Hockey Canada investigators, and only did so when she prepared a statement dated March 18th, 2025, after reviewing videos from Jack's bar during preparation for trial. All of these are inconsistencies, right? So it was suggested by Mr. Brown in cross-examination that she did not mention the bouncer because he could have attested to her state of intoxication. She replied that she wasn't thinking he could be helpful. She also explained that she was embarrassed about what had happened and did not want him to know, which seems not unreasonable, right? A video was shown to the complainant taken at approximately 1:20 a.m., showing her speaking to the bouncer alone for approximately 7 minutes, and it was suggested that if she wanted to get away from Mr. McLeod, she could have gotten help from the bouncer. She replied by saying that she was not trying to get away from him at that point, but pointed out she was showing visible signs of drunkenness by leaning on the wall, although she had no memory of interacting with the bouncer at present. Now, I lean on walls all the time because I got a bad back, so yeah. On the issue of her state of intoxication during cross-examination by Mr. Greenspan, the complainant was shown the video recording at Exhibit 34 and agreed with the suggestion that she had the wherewithal to realize that the bartender had shortchanged her when she ordered a drink. Wait, what? Wait, this bar sucks. The main thing I'm getting so far is that this bar sucks. 1/2-ounce shots, 7-ounce beers, and the bartender shortchanging her. I'm like, this is the worst bar in the history of bars. Okay. EM was also cross-examined about the shoes she was wearing that night, which were described as stilettos with thin high heels. She agreed that she wore the shoes all night while she was at Jack's bar, including when she was dancing. Now, this is kind of a thing because sometimes issues of clothing come up, but there is an absolutely forbidden inference. You cannot suggest, and it is not proper to suggest, and it's not, any you can't suggest that the shoes say that she was out looking to get up to something, right? Runkle is baiting a defamation suit from the bar. These are all this is all evidence from the court ruling. I'm like, what the hell? So the argument that is being made here is not that, because she had these shoes on, she was there for activity. But, yeah. The complainant did not recall exchanging Facebook Messenger messages with VH while at Jack's bar. They were shown to her in cross-examination and were filed as exhibits, whatever. When it was suggested to her earlier in cross-examination by Mr. Brown that she was texting on her phone, she thought she was scrolling and did not recall texting. After being shown these messages, the complainant said, and again used the term texting, which means something different than a Facebook Messenger. And, that is kind of a thing, right? A message sent by VH at midnight said, let me know if you want me to get you from the guy. EM responded that she was okay for now and would return soon, but she agreed that she did not return to join her friends. VH then texted EM 3 times without reply, then tried to call her as well. So VH offers a rescue. Hey, do you need help? And she says, no, I'm good. I'm all right. The following morning at 9:04, VH asked EM if she made it home all right, and EM replied that she did. and VH texted that she was not lit enough the night before. EM agreed and said they would have to go out and get really lit, meaning really drunk. She explained that she did not want her brand new friend to know her business, so she was talking to her as normal, basically denying, what happened. The video surveillance from outside Jack's bar shows Mr. McLeod and EM leaving the bar holding hands shortly after 1:30 a.m. Once outside, Mr. McLeod walks down the street quickly towards a cab, and the complainant follows behind him, almost running to catch up. So, the events at the Delta Hotel. Now they get to that. What topic are we on? We are on the hockey players' trial, the verdict. So, the events at the Delta Hotel. The surveillance video from the Delta Hotel is of assistance in establishing a timeline of the circumstances that follow. All right, we're going to skip through a little bit here because this is going to be a very lengthy stream otherwise, but yeah. So they entered through the main doors, with EM following McLeod up a short flight of stairs. It was suggested in cross-examination that she appeared to have no difficulty standing or walking as she entered the hotel. She testified that she had to really focus hard to get up the stairs. It was suggested that she skipped up the stairs without difficulty, and that she showed no visible signs of the consumption of alcohol. She agreed that it appeared that way on video. So you might be saying, why does it matter her shoes? Because the defense is not allowed to suggest you were in, sexy shoes, therefore you wanted to do sexy things. But she says she's super drunk, and she's wearing real pointy heels. And she's walking real fine in real pointy heels, which suggests that she's not as drunk as she was suggesting, right? That's what this evidence is about. And the reason why this matters is because if she is so drunk that she cannot consent, then they're guilty. Whereas the defense is arguing she's not so drunk that she can't consent, and she did consent. That's the defense's argument, right? So EM's version of the events in room 209. According to the events of EM, once they arrived at room 209, she went to the bathroom and removed her clothes and left them there. Then she had O and V with Mr. McLeod. Once it was over, she went to the bathroom to clean up, and Mr. McLeod got dressed. She returned to the bed naked and laid on top of the covers. She noticed that Mr. McLeod was on his phone texting. When confronted in cross-examination with the statement she gave to Hockey Canada investigators, she agreed that she was not so drunk at the time that she could not consent to engaging in sexual activity with Mr. McLeod. She agreed that she initiated O with him. When asked whether she recalled any conversation with Mr. McLeod about using a condom, the complainant stated, "That seems logical to me," but she could not remember any conversation. She further agreed that she initiated intercourse with him by getting on top of him while he was laying on the bed. The complainant testified in chief that she expected that she would be spending the night in the hotel room with Mr. McLeod. She did not recall any conversation with him about what would happen next. In cross-examination, it was suggested to EM that she made a suggestion to Mr. McLeod that he invite some of his teammates to the room. Initially, she answered, "No, I don't see that having been a, suggestion that came from my mouth. I don't think that was something I would have said." By O, we mean a particular type of sexual activity that I'm not naming the specifics of because YouTube might take us down midstream. So, yes. Although the complainant testified that she could not recall any conversation with Mr. McLeod, when it was suggested again to her in cross-examination that she asked Mr. McLeod to have some of his friends come back to the room because she was interested in having interactions with them as well, EM replied, "No, I don't think that would have been something I would have said." When it was suggested that she did not want to go home after engaging in sexual activity with Mr. McLeod because she wanted to engage in sexual activity with others, EM testified that usually around 2 or 3 a.m. would have been the time when she would be leaving, and she would have wanted to be going home. When pressed by Mr. Humphrey, she remained in the room because she told Mr. McLeod she wanted a wild night. She said, "Again, that doesn't sound like anything I would usually say, and I don't remember saying those words." EM testified that she next remembered Mr. McLeod leaving the room and 2 other men entering the room while she was naked on the bed. This shocked her. She was surprised. EM did not recall having a conversation with these men, nor did she remember if one of them had pizza. She remembered being naked on top of the bed when they came into the room. According to her testimony, shortly after the men came into the room, she went to the bathroom again. She got off the bed while naked and walked to the bathroom. When she came back out, she saw that more men had entered the room. So her vision of, like what's going on here, you can see that this is kind of threatening, right? That this would be, on her version of events, this is kind of a threatening circumstance where there's a bunch of guys showing up who she didn't invite and she didn't want here. And, and they're coming in while she's naked and all of this, right? So she indicated that she was feeling really uncomfortable and described herself as naked, drunk, and feeling vulnerable and scared. According to EM, she did not hear the other men entering the room while she was in the bathroom because she was still drunk. The complainant exited the bathroom naked and sat on the bed. She agreed with the suggestion by Mr. Humphrey that no one told her to come out of the bathroom naked and sit on the bed. She said it was just her body telling her to do that. She said it was an automatic reaction. She agreed it was possible she was being flirty with the men in the room. Now, here is the thing that I sort of think about, which is that, and this is a problem with her testimony. She's saying she feels uncomfortable with all these guys coming in. And what is the natural reaction if you're feeling uncomfortable with all these guys coming in? Would be to get up, run to the bathroom, and then you'd put your pants on, right? Like you would put clothes on. That just seems like the natural thing that would happen here, right? And but she comes back out naked, or maybe she locks the door. Maybe she calls maybe she texts her friend and says, I'm in trouble. Like bad shit's happening, right? I don't know. It's an unusual circumstance, right? And this is one of these things when they're determining, whether her evidence is credible, they have to determine if it makes sense, right? They have to determine if her evidence is something that, that fits. The complainant also agreed that no one took her clothes off or forced her to undress. No one moved her clothes from the bathroom, right? If they threw her clothes in the trash, then maybe that would be an explanation for why she doesn't put them on. She then went and laid on a sheet that had been put down on the floor. When asked how the bed sheet came to be on the floor, the complainant testified that they made a comment about wanting her to get on the floor, and she said no, so they laid a bed sheet on the floor for her. When asked in cross-examination why she did not simply return to the bathroom and put her clothes on when she saw the men in the room, the complainant replied that if she'd been sober and able to think clearly, she might have done that, but she was drunk and not able to think about that, and that was just how my body responded. She felt like she could not think clearly to make a choice. EM testified that there were 7 or 8 men in the room who were much larger physically than she was. Fair enough, right? They're hockey players. They're going to be big guys, right? They're big. They're going to be big dudes. Like, I am not a young naked woman. I might feel pretty uncomfortable if suddenly 4 giant guys I wasn't expecting show up, right? And so, there's issues of, does she feel threatened? Does she feel, all of these things, right? These are considerations. And I will just say, you don't have to agree with what the court found, right? The court makes certain findings and certain rulings and certain decisions, but ultimately you can disagree with them. That's okay, right? That we can all have our different sort of takes on what happens and so forth, but there's going to be a lot of discussion, there's a lot of social discussion of fawning, and which is sort of an adrenaline reaction, right? We can talk about that too. All right. EM testified that the men were talking loudly and joking with one another, and she felt like she was being bullied. According to her evidence, the physical contact with the men started when they wanted to touch herself or wanted her to touch herself and moan. The complainant testified that she was confused because she felt like she was watching this happening, and she could feel like I was watching my body doing this and acting like I'm liking it and doing what they're wanting to see from me, and it was confusing to know if I was liking the attention. She agreed that in her initial statement to Detective Newton, she told him that she was liking the attention for a little bit. EM was asked about her initial statement to police when she described comments that she alleges were made regarding golf balls and golf clubs being inserted into places as something the men were joking about, as opposed to the way she described it in her civil claim, where she said that the comments were intimidating and frightening to her. In response, the complainant explained that by the time the civil suit was filed, she had time to process her fear. So initially, her statement doesn't say she's afraid. Later on, she makes a follow-up statement where she says she's afraid. The other thing is, I will say, it is really a thing that if you give more than one statement, there's going to be inconsistencies. There will always be inconsistencies in the statements. And so, like, I tell clients, do not give statements, and then do not give follow-up statements. Do not any of these things, right? And she's in the difficult spot of she's had to make not just a statement, but a follow-up statement, and then a follow-up statement. And there's always going to be things that are, that are inconsistent with each other. The fact that there are inconsistencies doesn't necessarily indicate anything about credibility. It indicates that she made more than one statement. And the standard is proof beyond a reasonable doubt. That is the standard for conviction. And so note that proof beyond a reasonable doubt includes maybe did it. It includes probably did it. It's pretty close to, and might be over, almost certainly did it. I would say if you're at almost certainly did it, you're still not at proof beyond a reasonable doubt. You have to be at like, I am so sure kind of thing. So sure. And so there's going to be differences on this one, right? Now, the other thing I will note is that just because you might describe something as joking doesn't mean it's not. Jokes can be fairly menacing, right? So, yeah, but she's describing herself, in a sort of dissociative way. She's describing herself as heavily intoxicated, all of these different things, right? So, yeah. EM testified that the men were telling her what they wanted to see her do or telling each other what to do. She testified that some of the men started putting penises in my face and that she performed on 3 men. She could not recall if she assisted in pulling the men's pants down to do it. EM testified that she was being told to words and that the men were yelling other words and that she felt someone spit on her back and some slapping. She felt slapping on her butt while she was performing on the men. She felt as if her mind was separated from what she was doing. She described being on autopilot. She was asked if any of the men she performed on spoke to her directly. She said that she did not recall, but if they did, she was not really hearing it. This, again, sounds like a sort of dissociative kind of adrenaline response, right, is the way she's describing it. So, however, in cross-examination, the complainant agreed with the suggestion that she could not recall what, if anything, the 3 men said were directly before the began. The complainant recalled hearing comments like no phones or put the phones away that made her worry that someone was recording what was happening. Now, this one I go, maybe she's worrying that someone's recording, or it sounds like the guys are policing themselves and being like, hey, nobody record this. That's not cool, right? Nobody's allowed to record this. Chill out, right? EM testified that in her own mind, it was not what she wanted to be doing. She felt like she did not have any other option. She described it as her body protecting her from the situation. She testified that she did not know the men and did not know how they would react if she said no or tried to leave. So let's talk a little bit about this. And this is a problem that shows up with therapy. And one of the problems that shows up with therapy is that sometimes complainants are given language from therapists. And the problem is that that language may be accurate, but when the complainant starts giving the language that sounds like it's coming from a therapist, and to me, some of this sounds like it's coming from a therapist as opposed to from her experience, it starts raising credibility issues, right? It starts raising credibility issues of, is this her experience, or is she processing it as she's told that other people have had it happen? I don't know if EM is an example. The example I would give is not EM. The example I would give is Amber Heard. And a lot of Amber Heard's testimony, Amber Heard is she spent a lot of time testifying about like what she heard about how things go. EM is not at that level, but I get a whiff of it, if that makes sense, right? Now, but here's the flip side. Obviously, somebody who's going to be assaulted is going to go to a therapist and should, right? I actually think that we should have funding specifically for if you have been SA'd, that maybe we should like send some people, like there should be some therapy that goes with it, because part of our SA process, like the process of this, shouldn't just be about punishment, but it should also be about trying to fix the problems, right? It should also be about trying to repair the person. And to a certain extent that applies whether or not the allegation is true. And I know that's going to sound a little fucked up, and I'm still going to explain it, which is that even if the allegation is not true, there is trauma involved. So, yeah, it's, to me, all of this says like, this is a, this is a thing where therapy is meaningful, right? Also, we've hit a hot sauce goal, so I'm going to try a hot sauce as we go here. But, some of this, it makes it clear to me that she's spoken to a therapist. I don't think that should weigh heavily in this circumstance as against credibility. I will say that I have seen some cases where it does sort of raise more concerns for me, but this is not one of them. So, yeah. All right. She says that she did not know the men and did not know how they would react if she said no or tried to leave. It was suggested to the complainant in cross-examination that after performing O on the first man, she was asking other men in the room if they wanted to have sex with her. EM replied that she did not recall asking for that. She testified that she had no memory of saying anything. When asked specifically if she had said words to the effect of, "Come on, you've got a girl here. Someone have sex with me. You guys are pussies," EM testified, "That doesn't even really sound like how I would usually speak." However, she did remember someone saying, "This girl is fucking crazy." She agreed that could have been said in response to her saying, "Someone have sex with me." When it was suggested to the complainant in cross-examination by Mr. Brown that it is easier for her to deny the deliberate choices she made on the 18th and 19th than to acknowledge the shame, guilt, and embarrassment she felt about those choices, she responded by saying, "I don't know. I'm kind of struggling to understand that. I had a lot of blame on myself. I also do believe other people should be held accountable for their actions that night. I think it's just a combination of those things. This is evidence that is getting to be a problem for her. And this is her own evidence, right? This is because, if she says that she doesn't know whether it was easier to deny the deliberate choices she made, then she's really getting into some difficult scenario there, right? So it's becoming a little bit harder to see how a conviction could be reached, right? That is, and this is an illegal test, right? That isn't saying necessarily that bad things didn't happen. It's saying from the legal perspective. So, yeah. All right. EM described that after she performed O on the 3 men, she was laying on the sheet on the floor, and a different man who just had his pants off did the splits right over my face, and he put his penis right on my face. She did not recall something specifically happening before this, just that she was laying on the sheet. She thought this was kind of gross, and it felt degrading. When this was happening, she felt like the other men were making fun of her, like it was a joke to them. She agreed in cross-examination that she may have been acting like it was funny to her as well, to cope with the situation. The reason why they'd be getting that out is towards, what she was communicating, whether there was an honest but mistaken belief in consent. So yeah, the honest but mistaken belief in consent, in order to argue that, it has to not only be honest, but it has to be reasonable. So, yes. Further, it was suggested to the complainant that when she was on autopilot during these events, she may have been quite sexually assertive. She replied that she was not sure and did not recall. After further questioning, she stated it was possible she took on this personality to cope with it. Here's the problem, is that you can have coping strategies and so forth, but if you've got these coping strategies, then it may communicate consent. And yeah. EM agreed with the suggestion by Ms. Savard that she had almost no memory of what she may have said while in room 209, but when she said no to something, that boundary was respected. So she agreed that when she said no, people didn't do the thing she said no to. She agreed that she was missing memories of what was said by her and others about the terms on which she was willing to engage in sexual activity. EM also agreed that when she testified that she would or would not have done something, that she was relying on something other than habit because she had no habits consistent with this unusual event. I mean, this isn't really a consensual kind of thing, right? Or, sorry, this isn't really a usual kind of thing. I assume that it's not that, that this is something that's happening all the time, right? The complainant also agreed in cross-examination that she adopted the persona of a porn star because she thought this is what the men in the room wanted, and some of the things she was doing, she did without being told to, just to get it done and get out of the room. She also agreed that no one physically forced her to do things in that room, but the number of people and the jokiness with which they were approaching it, it did not feel like she had a choice. The complainant further described a further incident of sexual activity. She testified that the men were encouraging each other and saying, "Someone have sex with this girl," following which she got up and expected that this was another thing she had to do. So she got up and a man followed her to the bathroom. Although in cross-examination on this point, she agreed that it was possible she led him to the bathroom, but she did not recall it that way. She did not recall any conversation with him. The man put a condom on and bent her over the bathroom sink, and they had sex. And then the condom was removed, and she performed on him while she was on her knees and he was standing. The complainant believed that she did not remove the condom, that he did. The complainant did not know where the condom came from. She felt that the sexual activity was a continuation of what was going on. She felt separated from what was happening. She was feeling numb and like she had no control. The complainant identified the individual she had sex in the bathroom with on the team photograph entered as exhibit number 17. She identified him to this detective who wrote that what she said on the photo, Mikey's roommate in the room and sex in the bathroom. It is acknowledged that this person is Formenton. Although at another point in her cross-examination, the complainant was unsure whether the sexual activity in the bathroom with Mr. Formenton happened earlier, before the O, and she said it could have happened before, but she was not certain about that. So you can see there's a lot to this, right? It's very complicated, and different people are going to see different things here. After the sex in the bathroom, she went back into the room naked and laid on the bed sheet, even though her clothes were in the bathroom. She recalled that at some points during the night, she was getting up and getting her clothes on to try to leave, and then a man would come over and convince her to stay. She said someone would put their arm around her and guide her back to the bed sheet and try to convince her they were having fun. EM testified that she was crying at some point. And if she was, then that goes a lot towards saying maybe not consent, right? So, yeah. EM agreed with a suggestion in cross-examination that none of the men physically stopped her from leaving the room. When asked why she did not leave after coming out of the bathroom, since the door to the room was very close to the bathroom door, the complainant explained that she did not think of that. EM testified that at some points no one was doing anything. She started feeling sick, and she felt like she had to throw up but could not. They would notice she was crying, and they did not want her to leave while she was crying. EM testified that she heard someone say, "Oh, she's crying, don't let her go," although she could not identify who said it. She agreed in cross-examination this was the first time she told anyone that someone said those words to her. I.e., this is a new thing about the story, and that's going to be a problem for her case. So let's skip over sort of more of her story here because it goes on for a bit. But we'll cover some of the other issues. So the consent videos. While she was in room 209, Mr. McLeod recorded 2 brief videos of EM, which have been referred to as the consent videos. In the first video, recorded at 3:25 a.m., which lasts only 6 seconds, a number of male voices can be heard. The complainant is asked by a male voice, "Hey, you're okay with this though, right?" And she responds, "Yes, yeah." She's asked again, "You're okay with this?" And she responds while wiping her eye with the back of her hand, "Yeah, I'm okay with this." She was smiling in the video. When it was suggested to the complainant in cross-examination that if she was unaware that she was being recorded in that video, that she could not be acting for the camera when she said those things, she agreed that would make sense. But she did not recall what was really going on. She further agreed with the suggestion that she sounded positive in the video. In the second video, which is 12 seconds long and is timestamped 4:26, the complainant is standing while holding a white towel in front of her body, but otherwise appears to be unclothed. A male voice, identified as McLeod, can be heard saying, "Say it." EM, who is smiling and looking at the camera, says, "Okay, it was all consensual. Are you recording me?" Says, "Yeah." "Okay, good. It was all consensual. What else? You are so paranoid. Holy, I enjoyed it. It was fine. It was all consensual. I am so sober. That's why I can't do this right now." Let's just talk about this little bit here, right here. A voice saying, "Say it." So I'm just going to say this video right here has been spun multiple different ways because there's people online going, she's on video saying she was down with this, and I'm on video and I'm going, this video is awful. This video is terrible because them saying "say it" is, yeah. And Kate maybe saying this case reminds me a little. We've seen comments from chat that are a degree away from saying she was wearing X, so clearly wanted is archaic. Love you, Runkle, but this is where I tap out. I'm sorry, Kate. I'm trying to approach this with some sensitivity, but I cannot fully control chat. I like the "say it." If I'm the Crown, I'm saying this is consciousness of guilt. That's the argument I'm making. If I'm the Crown, is I'm absolutely arguing that this is consciousness of guilt, that they are worried that it was not consensual, and so they are making her say that it's consensual, and that they're making her say that it's sober or that she's sober because they're worried that it's not. So I've seen online people saying this video is great for the defense. And I'm like, I don't think that is true. Like, I don't think this is great for the defense here. However, they note, while speaking on the video, EM does not display any signs of intoxication. She has no difficulty speaking or standing. She's not slurring her words and speaks clearly and coherently, which suggests not intoxication, right? EM was shown the first video during her examination in chief. EM testified that she had no recollection of the video being recorded. She's asked at what point in the night the video was taken. She says it seems like it was towards the end of the night with all the men still in the room. She testified that she was probably on the bed sheet, and since she's wiping her eyes a lot, it may have been one of the points when she was crying. She testified that she felt, I don't really look like myself. She did not know whether when she stated she was okay with this, she was referring to a specific act. She testified that she wouldn't say it was a true reflection of how she was feeling about what was happening. EM thought this was still at a point when her mind is disconnected from her body and what she was doing. According to EM, she felt like the men were telling her she was okay with it, and she was going along with it, but she was not feeling like she was able to think clearly. When asked during examination in chief, the EM did not remember the second video being recorded either. In that video, the complainant testified that she believed she looked really drunk. Although she initially testified that she had no memory of the recording being made, she testified that after seeing the video, it refreshed her memory, and she recalled that this video was taken at the end of the night after the other men had left the room, and she was in the bathroom when Mr. McLeod entered and got in the shower and wanted her to get in the shower as well, and she did so. She testified that McLeod kind of told me to say it and was trying to get her to say what he wanted her to say on camera. She testified that although she said it was all consensual, that is not, in fact, how she felt at the time, i.e. that she might have been pressured into it. She testified that at the end of the night, around the time that the video was recorded, she went into the bathroom and Mr. McLeod came in and they had sex again in the bathroom. She could not recall if that took place in the bathroom or in the shower. She believed that she also performed at that point. In cross-examination, she agreed that the first time she saw the second video was during a police interview conducted on August 31st, 2018. She agreed that she was asked during the police if she had showered. She said she could not recall. She also agreed that she did not mention having sex with Mr. McLeod in the shower at the end of the evening when she first spoke to the police. It was suggested to the complainant that before the second video was recorded, there was some discussion with Mr. McLeod about how the sexual activity was consensual, and the complainant agreed that she recalled something along the lines of that, but she felt he was hounding her to agree to that. In cross-examination, when the complainant was asked why she said, "I'm so sober on the video," the complainant said, "I didn't feel sober at all," but when it was put to her at times that at times in the room when she was putting in considerable effort to be sober, she disagreed with that suggestion, despite the fact that she'd said just that earlier in her cross-examination. So, text exchange between EM and McLeod. He contacts her through Instagram and asked her to call him. Then they had a text exchange, which was introduced into evidence. Asked the complainant to call him, but she did not. He then asked her over text if she went to the police. EM explained that her mother had contacted the police, but she told her not to. According to EM, she was feeling nervous and scared about the messages, and she was starting to panic a little bit at this point. She texted that she did not want anything bad to come of it and told her mother to stop. According to EM, at the time that the messages were being sent, she was feeling scared. She resorted to trying to avoid confrontation and just keep people happy. She also testified that she hadn't really processed what had happened yet and hadn't realized that her mom had called the police already. So the following text messages were exchanged. "You said you were having fun." She says, "I was really drunk, didn't feel good about it at all after. But I'm not trying to get anyone in trouble. I know I was in the wrong too." When asked in examination in chief what she meant about when she texted, "I was in the wrong too," she testified that she was feeling like she was blaming herself a lot just for being at the hotel in the first place. She felt like it was all her fault and that she was trying to take some responsibility for that. Super common thing for people who are assaulted often feel guilt. But the line of I didn't feel good about it after is not great either. There's a lot of like mixed issues on this one. And I'll just say, guys, girls, whoever you are, try to arrange your life such that whenever somebody has relations with you, that they should feel good about it afterwards. Like, try to make sure that everybody who, who sort of, lets you sort of into their life in that way feels positive about the experience. So she then texted, I was okay with going home with you. It was everyone else afterwards that I wasn't expecting. I just felt like I was being made fun of and taken advantage of. So in chief, the complainant testified that is how she was feeling that night. She did not expect all the other men to come into the room, and they were laughing at her, and she felt ganged up on. She felt that she was being taken advantage of in that situation. And in response to that message, Mr. McLeod said that he understands that you were embarrassed about what happened, but she needed to talk to her mother to straighten things out with the police, and that her mother was misrepresenting what happened, and that could have significant implications for a lot of people, including the complainant. He then asked, what can you do to make this go away? All of this is not looking good either, right? Because this is looking like witness tampering or witness intimidation or the like. She says that it made her feel scared again because the message sounded threatening. And he sends a message, okay, can you please figure out how to make this go away and contact the police? And she says, okay. He later follows up with, hey, wondering what's happening. She sent this message, told them I'm not going to pursue it any further, and that was a mistake. You should be good now, so hopefully nothing more comes of it. Sorry again for the misunderstanding. And she also says that was not something she actually told the police. She just, she just wanted him to leave her alone. So, all right, we're going to skip over some of like the further statements and so forth. Evidence of the other people in the room. Tyler Steenbergen. He was a witness. He attended at Jack's bar. He says that he was drunk, but not overly drunk. I suspect everyone there was drunk. And he saw Mr. McLeod with a woman who was hanging off him, meaning fawning over him. He observed Callan Footy doing the splits while on the dance floor. I'm guessing that's like his go-to showing off move. Look how flexible I am. I can do the splits. Yeah, all the things he does to fix it are really incriminating facts. Really incriminating that he's trying to hide things, right? So he or someone else with him received a text message indicating that there was food in Mr. McLeod's room, so he proceeded to 209. When he entered the room, he saw a bunch of people. He testified that he sat at the desk at the far end of the room and then heard someone say, there's a naked girl in the bathroom. A few moments later, he observed a naked woman exit the bathroom. She appeared pretty normal. She was not crying and did not display any sort of reaction to seeing the men in the room. He said that he observed her go onto the floor onto a bedsheet that was at the foot of the bed. She began masturbating. Mr. Steenbergen did not remember anyone instructing her to do that. She did it on her own. I'm not even going to try to monetize this one, by the way. This is not going to... this is just like, I'm not even turning that on because I will totally get hammered if I do. Then the woman began asking the men to have sex with her. When asked in examination in chief what words were being used by the woman, he testified that she said, can one of you guys come over and fuck me? He felt like the men in the room were in shock when she said that. This statement causes attention, and he felt uncomfortable at that point. Mr. Steenbergen testified that he and some of the other players had girlfriends at the time and did not respond other than to laugh awkwardly. After she said that, he observed Carter Hart go over to her and receive oral sex. He unbuckled his belt and pulled his pants down to his knees. Mr. Steenbergen testified that the O was brief, maybe 30 seconds to 1 minute. Okay. Yeah. In cross-examination, The witness agreed with a suggestion that the woman called Mr. Hart over to her before she performed O, and that she might have assisted Mr. Hart in pulling his pants down. She agreed that she seemed into it, and that it seemed like a consensual sexual encounter to him. He testified in re-examination that he was not worried about the woman in any way, and it seemed like she wanted to do stuff. He could not remember whether he heard Mr. Hart say anything before or during the oral sex. When he stopped the oral sex by stepping back, he heard the woman say something like, "Oh, you guys are being pussies." So it looks like he stopped it midway through. In fact, looks like he said, "I don't consent to this anymore." So he testified that he observed Mr. McLeod getting a blowjob, which was similar to the way it happened with Carter Hart, fairly brief. I remember that he observed Mr. Dubé slap the woman's buttocks. He described it as not hard, but it did not seem soft either. The slap happened between the O with Mr. Hart and the oral sex with the O with Mr. McLeod. He testified that he heard a small slap, but did not hear a reaction from the woman. While this was happening, he was having a conversation with Jake Bean. In cross-examination, he agreed that it looked like foreplay, like light spanking or patting, not abusive. The mood was playful at that time. So he sees Callan Footy do the splits and could not see the woman because there were people around her. So he testified that she was being quite vocal about what she wanted and that he wanted no part of that. He estimated that he was in the room for 10 to 15 minutes. And yeah, he says that he left when she was in the bathroom. So they've got sort of a semi-independent witness who is like, I'm out, right? Like, we're out. All right, we're going to skip over a fair bit of the, the other witnesses there. But the other witnesses basically testify to, some of the other things there. Or some of the similar sorts of things here. Let's see. We've got Mr. Hart who actually testified. So he was the only one of them who testified. So we'll go over his testimony. Carter Hart testified in his defense. He was a goaltender on the team. He was 19 years old. He was in London with the team to celebrate their victory. So he had a good buzz going on, and he says he consumed 3 or 4 beers at Joe Cool's and had been given a contact name of the manager at Jack's and had testified him to let them know the team was coming so that they could skip the line. Drink special at Jack's, $1 beers, so that's what he drank. I mean, hey, if you're getting $1 beers, then I guess you're not worried that there's 7 ounces. Fair enough. So Mr. Hart testified that he received a text from Mr. McLeod in a group chat asking if he wanted to be in a 3-way and responded, "I'm in," because he was single at the time and open to sexual encounters. However, he was not going to make a decision about participating until he got to the hotel to see what was going on. Mr. Hart also received a call from Mr. McLeod, although he testified that he did not remember the details of the call. The gist of it was that Mike was with a girl at the hotel who wanted to have sex with some of the teammates. Mr. Hart agreed in cross-examination that he wanted to make sure that any sexual activity was fully consensual before he committed. So he says he was feeling pretty drunk. He's got gaps in his memory. And when he enters room 209, he remembers other guys being in the room, including Mr. McLeod sitting on the bed not wearing a shirt. He says that he sees her lying naked on the bedsheet, masturbating. She seemed to be enjoying it. So there's various people in the room, and he testifies that she says, "Can somebody come fuck me?" At that point, Mr. Hart testified that he felt excited because there was a naked girl in the room doing these things willingly. He'd never seen that before. According to Mr. Hart, some of the men in the room were encouraging each other to have sex with the woman, but most had girlfriends, so he said to her, "Can I get a blowy?" And she responded by saying, "Yeah," or "Sure," or something along those lines. He walked towards her, and she got on her knees on the sheet and kind of crawled to the end of the bed sheet, grabbed his penis over the top of his pants and pulled his pants down while he did the same. He was wearing joggers. So She says that she performed oral sex on him for 30 to 60 seconds. He was not able to get fully erect and didn't want to do it anymore. He described it as weird. So he then backed away, pulled his pants up, and returned to where he'd been standing previously. So basically, he's like, I'm getting too weirded out. So I also just want to say, like, if you assume everything here is consensual, then none of this was a good idea, right? And yeah, it's yeah. And also there may have been some drinking going down, right? Yeah. All right. He recalled that EM then sat on the floor, propped up against the bed. She seemed annoyed and said something like, "What's wrong with you guys? If no one's going to come fuck me, then I'm going to leave." He was shocked and could not believe the things that she was saying. He testified that she said things like this on more than one occasion. So he then remembered that when she went to the washroom with Alex Fermenton, he observed Mr. Fermenton walk over to EM and what is it? I'm adjusting some things here. What is it? There you go. After he made those statements, and then they held hands, and she led him to the bathroom. After Mr. Hart, or after they went to the bathroom, he heard a shower running. So, yeah, there you can sort of get a sort of sense of what is being said happened here. All right. So positions of the party. We're skipping along a little bit so that because otherwise this is going to be forever. Yeah, Egron's got a timeout, and if he keeps doing that, he's going to be it's going to be permanent. Katrina Bunny. If so many of them had girlfriends, why were they there? Well, because people are shitty. Is I guess the long and short of it. That is kind of it. So the positions of the parties, the position of the Crown. The Crown submits that it has proven each of the essential elements of the offense against each of the accused, and that accordingly the court should find each accused guilty as charged. You might say, wait a minute, isn't that always the Crown's position? Like, isn't it always the position of the Crown that that they should find each accused guilty as charged? Not always. Not always at all. I ran a trial for a client who was charged with possession of drugs for the purpose of trafficking. And at the end of the trial, the Crown got up and said, my position is that the Crown has not proven possession for the purpose of trafficking, but has proven simple possession. And therefore, we ask for a conviction on that count. And my position at that point was, I agree with the Crown. Let's get to sentencing. And my client got a small fine, which was great for the client. So, yeah, I mean, the other thing is it depends on who was being told what. Because if they were just told, hey, there's pizza. Like, if you're being told, hey, come... Like, I'm just going to say, if somebody texted me right now, and I'll just check my messages to make sure this is not happening. Oh, I do have a text. So, I am not being invited to a threesome. What is it? I am, however, my mom is sending me a kayak, and I'm being invited to go drinking. So, yeah, those are very, very different things. But, if I was getting a thing saying, hey, what is it? Come to a hotel for, whatever, I'd be like, nah, I'm busy. Right. I got places to go. But if I'm getting sent to like a message going, hey, do you want to come to the bar and go drinking? I'm like, yeah, that's fun. That sounds like a good idea, right? That sounds fantastic to me. I don't mind going to the bar. If somebody says, like, I've been at conferences, right? And if somebody says, hey, come on up, we've got pizza, I'm like, okay, pizza sounds great. Pizza better not be a euphemism. And yes, the only threesome Runkle gets invited to is Zora demanding snuggles with Runkle and Mrs. Runkle. That is also accurate. By the way, Zora does this cute thing, this insanely cute thing. So I'm awake at 2 a.m. And so I get Zora. I'm sitting there. I'm working on like just random shit. And Zora comes to the door and she scratches at the door. And I'm like, oh, what's going on? What's going on, pup? And she's like, it is time for bed. It is time for, time for sleep. And I'm like, but I'm not ready to go to sleep. And she's like, it is totally sleep time. So yeah, then when I finally do get to sleep, Zora follows. She was waiting outside my office. And what is it? She was waiting outside my office. And so when I went down to bed, she was like, all right, we're going. And what do you call it? Yeah. And then she climbs into bed to snuggle. So yeah, and this one is a fair comment. To me in this story, the pizza is the best sounding part. The pizza is really the only part of this that I'd want to have any part of. I also see people saying don't kayak and drink. I might drink a beer on the kayak. I'm not going to drink two. All right, let's take a short break. I see Pup Swoop. And Shay B says, my hubby, also a firearms enthusiast named Ian, asked if I'm watching and chatting with my other Ian. He's very confused about what you're talking about. We're talking about a very difficult case, but I got to also roll this. So we hit the hot sauce goal too. So the one I'm trying here is a Torchbearer hot sauce or Torchbearer sauces. Headless horseradish sauce. Miss Scarlett says, can we see the actual pups, please? Not really, because Mrs. Runkle is home. And I try not to, put Mrs. Runkle on that. Calendros, I haven't got the PDFs, so I'll have to check and see if they ended up in spam. I have not got those. Now, my tasting implement at the moment is based on I was doing some repairs. I don't have a spoon here. So I'm using a screwdriver. This could use more horseradish, but the horseradish is quite pleasant. It's quite tasty. It doesn't initially have much burn. It's got a slow sort of afterburn. First ingredient is horseradish, then ghost chili pepper, garlic, canola oil, water, chipotle peppers. It does eventually get bitter. So I don't like the bitter aftertaste. Or like they need to do something to cut that bitterness, I think. It's otherwise a really good sauce, but the bitterness, like the bitter aftertaste on it, is not wowing me. I mean, I'm going to use it, and I mean, this would be great on various kinds of meat, but the bitter aftertaste is a substantial downside. I don't know how to fix it. I don't know like what to do, and I'm normally pretty good at like tasting something and then go. People are saying maybe it's the screwdriver. No, the screwdriver's fine. It's not the screwdriver. It's the sauce. Yeah, it's and I can try with just like, not a screwdriver, but just like the end of my thumb here. Yeah, no, the bitterness is from the sauce. Salt and believe it or not, MSG. MSG is also sort of helpful for that. Did we hit our second hot sauce goal? We didn't. We did not hit goal for hot sauce number 2. I'll start that up again. Yeah, it's the horseradish. Like the horseradish is just doing that. So I like it, but not as much as I like the ones like the real treasures were the ones from yesterday. The other Terra Torte, we haven't gotten to the P320 yet. This Dawson's hot sauce, I've got some chicken in the other room. Yeah, this is good. This is really good. I really like this one, the big smoke. It's got a nice sort of smoky aspect. I've got chicken in the other room that I'm going to eat later, and yeah. All right. Yeah, I see this is a fair comment. You can combine the first missed goal with the second and call it complete. You're not wrong. Horseradish isn't bitter. It can become bitter when it's fermented. That's the thing. Fermenting it makes it more bitter. So I picked this one up. Collards and Ghost. Collards and Ghost. It's where's my knife? I picked this one up purely because I was like, I don't know if this will be good. I don't know if this will be, if this will be tasty. But I like that they're trying something different, right? I like that they're trying something unusual. Because, I mean, let's face it, there's a ton of hot sauces on the market at this point, and a lot of them get kind of samey. So I'm just, I like that they're trying something different. Hot and saucy gives you heat without sacrificing flavor. Made in all batches with all natural ingredients. We're as local as possible. We don't use any additives, so the heat and color may vary by batch, but the unmistakable flavor will always be the same. Pairs great with chicken, tacos, fish, and eggs, or uses a cooking sauce. And where's this from? First ingredient is collard greens. This is from Georgia, apparently. Ghost peppers, extra virgin olive oil, onion. All right, let's give it a go. I found a skewer. We're going to use the skewer. All right, here we go. I don't know if I like this, but I don't hate it. The collards are a very strong flavor, and it is kind of a spinachy flavor. I don't hate it. I don't know what I think about it. I got to try it on like chicken. I'm going to try this on some food later. New here, explain hot sauce goals. So YouTube lets me set goals for like super chats and so forth. And so just for fun, I just, try hot sauces and do various things on those things. I'm a big fan of hot sauces. So yeah. This one's got like a slow, long burn. It's like sometimes you get sauces that have like an initial spike, and like sometimes you get sauces like this one that sort of have a slow thing and then peak up. This one goes and it just holds for a long time. That's interesting, because I still feel it's not super spicy, but it still feels kind of peppery. So don't hate that at all, actually. Yeah, I will we'll have to give that a go. I have chicken that I cooked, and I didn't get the chicken timing right. So the chicken was done 5 minutes into my stream. All right, let's we'll do another swoop and then we'll get back to it. Here's a good swoop. There we go, little bear. So let's get back to the case. All right. So the Crown asked this court to find that the complainant in this matter was a credible and reliable witness, and that her evidence should be accepted in its entirety. Intoxication does not equate to unreliability. The Crown says that her evidence was not shaken in any material way during cross-examination. She was clear and consistent about her lack of consent. She was fair. She acknowledged possibilities when put to her in cross-examination. It is submitted that any inconsistencies in her evidence were minor and related to peripheral issues, and that she provided explanations for those inconsistencies. So this is a big thing, right? If you have inconsistencies in your evidence, because nobody is going to say the same thing twice, right? Everybody's going to have inconsistencies. But the issue is, are they significant, right? You know, did I have one drink or two is going to be a, not a big inconsistency. But did I have one drink or 9 might be a big inconsistency. Was there a gun present or not is a big inconsistency, right? Moto mining BC is difficult, and I'll have to get to that in a different time and place here. So yeah, and this is the other thing. It can actually be a little bit of a red flag if everything is too consistent, right? So the evidence of the complainant was corroborated in important ways by other evidence. The Crown points to the video from Jack's bar, for instance, which confirms the number of drinks she consumed. Many of the acts that she described were corroborated by the evidence of Tyler Steenbergen and Brett Howden. It is submitted that the complainant did not have a motive to fabricate her evidence. She acknowledged that she cheated on her boyfriend. Then she testified that she told him about these events. The civil suit against Hockey Canada was not filed until 4 years after she first went to police, and does not provide a motive. I.e., she reported to the police first, not after, right? As for the other witnesses, the Crown submits that some aspect of Tyler Steenbergen's evidence may have been consciously or unconsciously influenced by the group chat, but he was forthcoming in his evidence in chief. His evidence in cross-examination ought to be approached with caution. The Crown submits that Brent Howden, a witness for the Crown, was clearly influenced by the group chat. It is submitted that he remembers more about what transpired in room 209 than he admitted at trial. It is submitted, however, that those portions of his testimony and his past statements that were adopted during his evidence can be and should be accepted by the court. It is submitted that the evidence clearly establishes that it was Mr. McLeod's idea to invite his teammates into room 209 for sexual activity, and that EM did not know and did not consent to that sexual activity. That is supported by the text sent to him by him to all his teammates, and by his offer of a gummer to Boris Kachuk, while EM sat quietly and did not say anything. It is submitted that the complainant testified that she had no memory of any conversation about other men coming into the room, nor would she have asked him to invite other men into the room for sexual activity. Their arrival in the room was a surprise to her. The Crown argues that this case is about whether there was sexual touching that took place between each of the accused and the complainant that she did not voluntarily choose to engage in when it was happening. That's the correct legal standard, right? So, yeah. The Crown submits that the evidence of EM, supported by the other evidence, including the video evidence, the text messages, and the evidence of the Crown witnesses, should not leave the court in doubt as to the guilt of each of the accused. So, the Crown further submits that the credibility and reliability of each of the men who were in room 209 is compromised as a result of the group chat that took place on June 26th. The accused were actively engaged in getting their stories straight and were likely tainted by what was said by others. This was an effort to construct a narrative of the events that was not true. The Crown argues that the court should find that the accused who participated in the group chats concocted a narrative to portray EM as instigating all the sexual activity that took place. As for the credibility of Mr. McLeod, the Crown submits that the exculpatory portions of his evidence should be rejected. It is submitted that he intentionally lied to the police when he voluntarily provided a statement because he did not tell the police that he invited the players into his room by sending out the message, "Who wants to be in a three-way quick?" This calls into question his credibility. The Crown submits that parts of Carter Hart's evidence should be rejected, and it should not leave the court with a reasonable doubt. Mr. Hart initially testified that he told EM that he'd be open to receiving a blowjob, but not sex. He said he was open to taking her up on one of her offers, but acknowledged that she did not offer oral sex. There are also issues with the reliability of his evidence. He was admittedly intoxicated on the night in question, and it is submitted has major gaps in his memory. So intoxication does not affect his reliability, but intoxication doesn't affect reliability, but intoxication affects reliability. You can see there's this is kind of a problem when you have like two different witnesses and you need to, it is submitted that EM did not make a voluntary choice to perform oral sex on Mr. Hart. Her ability to choose was constrained by her intoxication and her vulnerability in this situation. The complainant testified that she felt she was not in control of her body. EM does not remember asking for or demanding sex from anyone. The Crown submits that these words were not spoken by her. So basically the Crown is saying, definitely we should, take her view. As it relates to Dylan Dubé, the Crown submits that the complainant testified that she was not consenting to being slapped by anyone, and should find that Mr. Dubé slapped the complainant hard on the buttocks while she was performing oral sex on Mr. McLeod. A slap can be sexual assault. Just absolutely can, right? 100% it can. There's actually a case where a guy was convicted of sexual assault because he pretended to work at a shoe store. And then women would come in and they'd be like, "Hey, I want to buy some shoes." And he'd be like, "All right, let's get those shoes off." And then he'd handle their feet. And the reason why he would do this is because he is a foot fetishist. And so he was tricking them into letting him touch their feet because, foot fetish. And it was found that their consent to touch, their feet was not valid because it was obtained by trickery and deceit. And also that it was done for a sexual purpose, because even though feet are not necessarily a sexual part of the body, that his purpose was sexual, and therefore it was a sexual assault. Because doesn't matter, any contact that is for a, for that. And I will say, I'm not going to disparage all feet people. There are plenty of ethical foot fetishists out there. But I will say some of the weirdest files I have seen are foot fetish people. And I don't know why. I don't know why this is a thing. But when you hear about somebody climbing under a cubicle wall to touch their coworkers, it's feet. Right? It's that's the thing, right? So I don't know why there's weird foot fetishists out there, but there are totally weird foot fetishists out there. And it is a whole thing. All right. Both Mr. Howden and Mr. Steenbergen testified that they saw a slap, and Mr. Howden agreed that he left quickly after this happened. It is submitted. This is why Mr. Dubé called them and asked them to lie to Hockey Canada about his involvement by leaving his name out. It is submitted that Mr. Dubé is also guilty of sexual assault in relation to the oral sex he received from the complainant. She did not make a voluntary choice to perform oral sex because her ability to choose was constrained by her intoxication and her vulnerability. So basically, they are saying she cannot consent because she's too drunk, and because any consent that she got was because there's these guys who are making her scared, and that, the consent is, yeah. Emotional Lemonade says, I'm a pro dominatrix. The foot people are the weirdest. I have heard this from many, many sex workers, believe it or not. And you might be saying, Runkle, why are you talking to sex workers? Because they're people. And that's it. So also sex workers get a lot of self-defense cases, and I'm a bit of a bleeding heart. So when I take the sex worker self-defense cases, I don't want to charge money for them, which meant that I got a lot of people calling me being like, hey, I'm being charged because I have a knife in my purse. And I was told that you would help. And I was like, yes, yes. I don't know. I don't think it's right that we charge women who are, sometimes pressured into it by circumstance for having tools to defend themselves. So, yeah. It is submitted by the Crown that EM was not consenting to the oral sex with Mr. McLeod because she did not make an affirmative choice to engage in that sexual activity with him. She felt she was doing what was expected of her. It is submitted that the vaginal sex that took place between them at the end of the night was also an incident of sexual assault because she did not consent to the vaginal sex at the end of the night. The complainant testified that it was a continuation of the rest of the night and just something she needed to do and not something she really wanted to do. The Crown submits that the consent videos do not provide evidence of consent because the complainant must provide her voluntary agreement to engage in sexual activity at the time that it is happening, but it is important evidence to support that Mr. McLeod knew that she was not consenting to this activity and that this is the reason for making the recording. This I think is actually the best argument. And Shay, we're getting to that. We've talked about that a little bit, but we're getting to that. I actually think this was the Crown's best argument. Is that this recording with the say it, is, that this is the Crown's. If I'm the Crown, I'm making this the showpiece of my argument. That they knew that they had done wrong because they're saying, say it, and they're making her make this video. But that can cut both ways, right? So, as for count number 2, the charge of being party to the offense, they say he took steps for the purpose of encouraging the other men to commit the offense of sexual assault. He encouraged men to come to the room with a 3-way text, and he offered that she would perform oral sex on Mr. Kachuk. He did so without her consent. He should be convicted of that offense. They also note that even if the Crown argues that even if the complainant did say the words, isn't anyone going to fuck me, that does not mean that she made a voluntary choice to have sex with Mr. Fermenton in the bathroom. I feel like that is that's a much harder sell, right? I think that one is a much harder sell, right? Like, if she says, isn't anyone going to fuck me, and then leads the guy into the bathroom, that kind of suggests that is something that, that she's trying to, yeah. I feel like this argument by the Crown undermines their other things, so, yeah. So the best evidence that this was non-consensual is a video of her saying it was consensual. I agree the say it is problematic. I just find the reasoning flawed. I can just say that there are plenty of cases where, let's imagine you've got a domestic violence allegation and the guy calls her from prison and says, hey, I need you to recant your story. And then the next day she goes to the, police and says, hey, it was consensual. Like, I agreed to get, slapped. Then that's going to be good evidence that it in fact wasn't consensual, right? Because it's evidence of, it's bad, right? It looks bad if you are having to make sort of a hostage video after the fact, right? So, so the position of Michael McLeod. So we're going to get positions from each of these things, or from each of them. So their case for the Crown rests entirely on the credibility of EM, and they testify that the court should have serious concerns about the credibility and reliability of her evidence. They say that her claims of non-consent are undermined by eyewitness, evidence. They say that she engaged in an alcohol-fueled night of disinhibited sexual activity in which she was a willing participant and which she later regretted. What she described as disrespectful treatment at the end of the night propelled her to develop a false narrative of the events. So she didn't like how things went down. She didn't feel that that was great. And therefore, she made a note there. They say it's preposterous to believe that because she was scared, she initiated sexual activity with the room. It is with men in the room. It is more likely she made a regrettable choice to give in to sexual attraction, to be sexually adventurous with men she just met, and that her concern for her reputation caused herself to present herself as a victim. Can we talk a little bit about the sexism that comes up here? Because I just kind of go like, we judge women really hard if they do something sexually aggressive, sexually adventurous. And at the end of the day, I'm like, if she wants to have sex with a bunch of guys, that should be okay. If she didn't want to have sex with a bunch of guys and she was forced into it, that's not okay. But if it was a consensual activity, and I've seen a lot of people online who are being shitty. I've seen a lot of people online who are like, they're calling her they're calling her, all sorts of things, words I don't even want to repeat. Right. And, I'm like, no, like, just whatever. Similarly, I see people talking about the guys and saying they're engaged in disgusting sexual activity, therefore they should go to jail. And I go, also, no, like, none of this is something I want to participate in. It's not for me, right? It's not a thing that's like, but I also don't want to go skydiving. I have a fear of heights. I do not want to go skydiving. But that doesn't mean that I'm going to decide that somebody who is skydiving is necessarily like, a criminal or an asshole or anything like that. I feel like the world might be a better place if people just chilled the fuck out about like sex in general. Because there's people who want to be sort of prudes, if you can put it that way. And there's people who want to be adventurous. And like, there's an entire universe full of people who are, down for whatever they're doing or not down for whatever they're doing. Like, I don't know. Like, yeah. All right. So the defense asked the court to consider the evidence of the Crown's own witnesses who testified that the complainant was the one initiating sexual activity in the room. It would be preposterous to believe that because she was scared, she initiated sexual activity with the men in the room. It is more likely she made a regrettable choice to give in to sexual attraction, et cetera, et cetera, et cetera, and that her concern for her reputation caused her to present herself as a victim. This is supported by the fact that she changed her mind 5 times about whether she wanted to pursue criminal charges. According to Mr. Humphrey, the complainant did not claim to be scared when she was in room 209 until she filed the civil claim against Hockey Canada in 2022. This was a claim that was scripted after the fact to remedy the deficiencies in her first narrative. It is argued that this false narrative was used by the complainant to support her civil suit against Hockey Canada, i.e. it suggested that she has a financial motive, right? That she's got a financial interest in all of this. She said it's inconceivable that it would take years for her to process her fear. Now, the thing is late reporting is not, is not evidence of consent. The fact that somebody doesn't report something right away doesn't mean that they consented to it. That's just not how that goes. And yeah. All right. So you got to be careful on all of that. The defense also submits that the court should not accept the complainant's claim of intoxication to a point close to incapacity. They say basically there's video showing her not that drunk and evidence showing her not that drunk. All right. So we're going to skip over the position of everyone else because they're basically kind of the same positions. They all say consent. So we're going to get to the presumption of innocence and the onus of proof. This is essential for every court case, the presumption of innocence. And it's something that makes people very upset about, especially in sexual assault cases, because they say, why is the standard so heavily against, why is the evidence so heavily against, weighed against the complainant? And the thing is because at the end of the day, if the accused are acquitted, the complainant doesn't go to jail. But if the accused are convicted, they go to jail. And they probably go to jail for like 3-4 years, right? They spend several years in jail. Their life gets, blown up, right? So the standard is obviously going to be high. And I've had arguments about this online. I had people saying, this isn't fair to the complainant. The process isn't really about being fair to the complainant in that sense, because it's not a he said, she said, and like both are sort of equally weighted. It's a he said, she said, and we only convict if the proof is beyond a reasonable doubt. That's where it has to be. It has to be beyond a reasonable doubt. Always, right? And yeah, unless you're Brock Turner, yeah, that's a whole other shit show. So yeah. Each of the accused is charged with sexually assaulting her and being a party. Each of the accused is presumed innocent of those charges unless and until the Crown has proven their guilt beyond a reasonable doubt. I like this language, unless and until, because usually you say like guilty until proven innocent, or innocent until proven guilty, rather. And innocent until proven guilty makes it sound like we are assuming that they are going to be, proven guilty, which isn't an assumption we can make, right? We can't assume that they're going to be proven guilty. It's just, it might happen, right? So, yeah. And whoever, I am really sorry to hear about what you went through there. Took me years to understand this, and I forgave the guy who did that to me, and only recently forgave the prosecutor for that weak-ass plea deal they gave him. It took LawTube to make me understand. I'm really sorry for what you've been through, but I'm glad that in some way there's some healing to come out of discussion of this. So, yeah. There is a high criminal standard of proof which applies to the Crown's case against each of the accused. The Crown must prove each of the essential elements of the offense charged against each of the accused beyond a reasonable doubt. The concept of proof beyond a reasonable doubt is a cornerstone of our legal system. A reasonable doubt is not based on sympathy or prejudice. It is based on reason and common sense. It is logically derived from the evidence or the absence of evidence. Now, what would it be an example of the absence of evidence being helping establish reasonable doubt? Well, let's say Bob says I shot him with a shotgun, right? And, Bob says I shot him with a shotgun. Okay. Was there blood? Was there, did he have any medical conditions? The medical condition of having a hole shot in him? Because if there's none of that, we can probably conclude, oh, my mic is doing a thing. 1 second. Okay, hopefully that'll fix the mic. I don't know why the mic does that, but it does that sometimes. So, yeah. That would be an absence of evidence. No evidence has been called as to blood or organs or, the guy being dead. And so, maybe it didn't actually happen, right? The absence of evidence. Once it starts acting up, it'll probably do it again, but we'll try to do our best on that. So, yeah. The Crown is not required to prove a criminal charge to an absolute certainty, but the court must be satisfied on the basis of all the evidence of the guilt of the accused beyond a reasonable doubt. Absolute certainty versus, beyond a reasonable doubt. You can have unreasonable doubts, right? Although the accused are charged on the same indictment, they are not charged as co-accused. They are charged individually with having committed offenses of sexual assault against DM. The court must consider the totality of the admissible evidence as it relates to each of the accused individually to determine whether the Crown has proven the case against each one of them. So, essential elements of the offense of sexual assault. So, essential elements are one of the things you have to do as lawyers. One of the critical things you have to do for lawyering in criminal law is you have to be able to break down an offense into the elements of the offense, right? What are the things that the prosecution has to prove? And so the three elements for the actus reus of this is A, a touching of the complainant by each of the accused, B, that the touching was of a sexual nature, and C, the absence of consent to the sexual touching. So the first two elements are objective, and the third element, consent, is subjective. So objectively, was there a touch? Objectively, was it of a sexual nature? And note that the objectively wasn't of a, or objectively of a sexual nature means that even if the person says it wasn't sexual, you can still convict, right? As in the case of the feet case and so forth. And the absence of consent is subjective on the part of the complainant, right? Does the complainant say, did the complainant actually consent, right? And that's in their mind, right? So, yeah. The Crown must prove each of these essential elements of the offense beyond a reasonable doubt. In this case, except for the conduct of Mr. Footy, which it was submitted did not constitute a sexual assault, there is no issue that each of the accused had sexual contact with EM. The issue is whether that contact was consensual. The accused are not required to prove that the complainant consented to the sexual contact. The onus is on the Crown to prove beyond a reasonable doubt that the accused had sexual contact with her without her consent. This is important. The defense does not have to prove consent. The Crown has to prove not consent, right? So that is a critical thing, right? Because otherwise you're reversing the burden of proof. And so if you don't know whether she consented, then you have to acquit. Now, keep in mind, I don't know whether consent happened in this case is a gross situation, right? This is a gross situation in that case. But you can't convict there. Why wasn't this a jury trial? Fun story about that. Fun story. It was originally a jury trial. And the jury, there were multiple mistrials, and eventually the jury was dismissed and they continued it as a judge-alone trial. And there were allegations made that the defense counsel screwed up and caused caused things. So there was one situation where there was an allegation that one of the defense lawyers approached a juror and spoke to them. So, yeah. It's but at the end of the day, They dismissed the jury, and it became a judge-alone trial. I thought Canada almost never did jury trials. Most trials in Canada are not jury trials. Most trials in Canada are judge-alone. But for certain offenses, especially like serious SAs, there tend to be more jury trials. So, yeah. Insofar as consent is concerned, the question at the actus reus stage is solely whether the complainant, in her mind, wanted sexual touching to take place. Keep in mind, that makes it very easy for the Crown, right? Because usually the testimony of the complainant on that, on that point will be accepted. In addition to the actus reus, the Crown must prove the mens rea of the offense, that is, that the accused knew of or were willfully blind to or were reckless about the absence of the complainant's consent to the sexual activity. So, as an example, let's say I go up to let's say I go up to Mrs. Runkle and I go, "Can I kiss you?" And she goes, and she shrugs. And I think that she's doing it playfully, but I go and kiss her. Well, the court might find that that was me being reckless as to whether or not there was consent, because, what does that shrug mean, right? Does the shrug mean yes, go ahead, or does it mean no? So, yeah. Since consent requires the voluntary agreement of the complainant must be capable of understanding that they have a choice of whether or not to engage in the sexual activity in question. The capacity to consent requires that the complainant be capable of understanding what is required for subjective consent. No more, no less. Note that capable of understanding is pretty low, right? It's a pretty low standard. No consent is obtained if the complainant expresses by words or conduct a lack of agreement to engage in the activity, or if the complainant, having consented to sexual activity, expresses by words or conduct a lack of agreement to continue to engage in the activity. So, if somebody says, hey, please have sex with me, and then midway through having sex, they go, I'm not feeling it anymore. Stop. You got to stop. Consent over, right? Consent done. And that means the sexual activity has to end as well. Intoxication is a factor to be considered in assessing the capacity of a complainant to consent to sexual activity. And they note, obviously, equating any degree of intoxication with incapacity would be wrong in law. A lot of people make this argument online. You'll see a lot of people who say, if you're drunk, you cannot consent to sex. And it's legally wrong. It's legally bullshit. Because, let's say I've had 6 beer. I've had 6 beer before, right? Let's say I've had 6 beer. At that point, I'm feeling pretty, pretty loosened up, we'll go with. I'm feeling pretty cheerful. I wouldn't drive a car at 6 beer. I just wouldn't. I mean, I might still be legal to drive one, but I wouldn't drive one at 6 beer. And, but that, I'm still, it's not a point where you're just because you're drunk doesn't mean you can't consent. If you're tied to a chair in a mob boss's basement and say, "Are you going to kill me?" that isn't asking to be killed. Correct. But if you say something like, "If no one's going to kill me, then I'm leaving," then that might be more suggesting that you're yeah. So, yeah, it's kind of a, kind of a thing there, right? Let's see. That goal ended. We're going to start another goal, and the goal is going to be umami bomb. I bought an umami bomb thing for shiitake chili oil. Will it? There we go. That is going to be our goal here. Yeah, you're also not allowed to consent to being killed. So, yeah. All right. Proof of intoxication or of a complainant's lack of memory are not enough to establish lack of capacity, although evidence of both is relevant. So what that means is you can be drunk to the point where you blacked out and you have no memory of it, and it still doesn't tell you that there was no consent. Now you might be saying, what the hell, Runkle? What do you... And I'm saying this is the court actually describing the law, right? This is the court describing the law correctly, right? This is the law as it stands. And so you can say, I don't agree with this, and that's fine. You don't have to agree with this, right? But if you don't agree with it, that's not the same as it not being true. This is just how the law works, and it's okay to have disagreements about how the law works. So, yeah. What is MAID? Medical assistance in dying. It is you get a doctor to kill you. So, yeah. All right. The provisions of 265 are incorporated into the definition of consent. That section states that no consent is obtained where the complainant submits or does not resist by reason of threats or fear of the application of force to the complainant. And in Chutery, the court said that the following in the context of an application to admit evidence of other sexual activity, but the reasoning of his assistance. First, while there are no bright line rules, trial judges should use their common sense and not artificially parse a sequence of events that may be integrally connected. For example, other sexual activity may include sexual words and gestures that are anchored to the sexual activity that forms the subject matter of an alleged sexual assault because they were made immediately before, during, or immediately after the sexual activity at issue. And now they're going to talk about assessing credibility and reliability, right? So in The King and Crook, the Supreme Court set out the difficulty that trial judges often encounter in assessing the credibility and reliability of the evidences of witnesses. The court said, assessments of credibility and reliability can be the most important judicial determinations in a criminal trial. They are certainly among the most difficult. This is especially so in sexual assault cases, which often involve acts that allegedly occurred in private and hinge on the contradictory testimony of two witnesses. The trial judge, while remaining grounded in the totality of the evidence, is obliged to evaluate the testimony of each witness and to make determinations that are entirely personal and particular to that individual. Credibility and reliability assessments are also context-specific and multifactorial. They do not operate along fixed lines and are more of an art than a science. With respect to credibility in particular, while coherent reasons are crucial, it is often difficult for trial judges to precisely articulate the reasons why they believed or disbelieved a witness due to the complex intermingling of impressions that emerge after watching and listening to witnesses and attempting to reconcile the various versions of events. The task is further complicated by the trial judge's ability to accept some, all, or none of a witness's testimony. So when you think about like accepting some of a witness's testimony, what does that look like? Well, let's say that, let's say I testify that I went to the bank because, I went to the bank because I needed to like make a deposit. I walked into the bank and then I saw like Bob, and I didn't talk to Bob because I don't like Bob. And I just went up to the teller and I did my business and I left. And the court could be like, well, I do believe that Mr. Runkle went to the bank for the purpose of making a deposit. And, but I don't believe him when he says he never talked to Bob. I believe instead that he went up to Bob and he punched Bob in the face because, Bob is a very punchable face. So that's the court accepting some of my evidence, but not all of my evidence, right? And the court can accept none of it. They can say, Mr. Runkle, all of what he said is bullshit. We don't accept any of it. Or they can say, everything Mr. Runkle says is true, right? They can do all of that stuff. The court goes on to refer to the common sense assumptions that underlie all credibility and reliability assessments. Paragraph 73, the court recognizes that common sense underpins well-established principles guiding credibility assessment, including the now universal idea that witnesses who are inconsistent are less likely to be telling the truth, and assists in assessing the scope and impact of particular inconsistencies. Reliability also requires reference to common sense assumptions about how witnesses perceive, remember, and relay information, invoking generalizations about how individuals tend to present information that they are remembering accurately and completely, as opposed to matters about which they are unsure or mistaken. A trial judge may, for example, infer that a witness was credible yet unreliable because they appeared sincere but displayed indicia that tend to suggest an unclear or uncertain memory. For example, equivocation, phrases such as let me see, long pauses, or failure to provide much detail. Let's give an example. They say, Runkle, where did you eat dinner today? And I say, I haven't eaten dinner. Real quick, real simple answer, right? But compare and contrast. Let's say they say, Runkle, where did you eat dinner last night? And I say, I don't think I ate dinner. Which one of those sounds more accurate, right? Which one of those do you have greater confidence in? Now, here's the problem. Is that there's a whole bunch of things that affect our presentation of credibility that, in fact, are irrelevant to credibility. I had a witness, I had a client, an accused, and he was like, hey, do you think I should testify? And I was like, nope. And the reason why I didn't think he should testify was because he had anxiety. Super, super anxiety. And everything the guy said sounded like a lie because he was super, super anxious. And I was like, it is not a good idea for you to testify because everything you say sounds like a lie, even though it's true. Because the guy was so anxious, he would be like, so what did you have for dinner? I had steak. Yeah, steak. I had steak. Guy's telling the truth. He's got no reason to bullshit me about having the steak. But the it makes it sound like he's lying, and you hear the guy and you're like, why is he lying about his dinner? I have had another guy who, when he got up to the stand, the first question I asked him was about about the fact that he was anxious. And, that guy had to testify based on basically the circumstances. And the first thing I'm asking is, do you have any conditions that you want us to know about? And he's like, yes, I have diagnosed anxiety. And I'm like, cool, excellent. And the reason why I wanted that to get out there is because when the trial judge is judging my client in his honesty, I want him to know that my client is just super anxious as a person, right? But you get other things. You get other other issues. One of the ones that came up in Canada is specifically with regards to the Inuit. And if you don't know who the Inuit are the indigenous peoples of like northern Canada and northern Alaska. And you might be saying, isn't there another word for them? Yes, but it's considered a slur. So the Inuit. Culturally, the Inuit do not really believe in eye contact. Eye contact is really kind of rude. And so when you're talking to Inuit people, they may look down a lot, and they'll look at you and then they'll look away. They'll look at you, look away. And we take that as like people in sort of Western culture, we take that as deceptive as fuck. We take that as this guy's a lying sack of shit and can't look me straight in the eye because he is a lying sack of shit. And it's not that they're liars. It's that they have a different cultural cultural thing where they look away from your eyes, because looking at your eyes is considered a bit of a dick move. You get people who are autistic who don't want to look you in the eyes. You get people who are shy, right? All of these things. And so one of the strongest things for like credibility assessment, in my view, isn't that they like behave in a particular way. It is that the people, when you see people's behavior change. And so what you'll see sometimes is people, you see this all the way through the Karen Reid trial. You know, when you see the example of the Canton brainworms, right? And so when you see somebody whose memory is like, you know, their memory is just perfect until suddenly they're on cross and now suddenly they can't remember shit, right? You get a baseline and then you see how that baseline changes. And that is a critical thing for assessing credibility. So, yeah. All right. Let's have a, let's go on here. So, as recognized in Ewanchuk, the statement of a complainant that she did not consent to the sexual activity in question is a matter of credibility to be weighed in light of all the evidence, including the complainant's words and actions before and during the incident, including any ambiguous or contradictory conduct. The court is entitled to disbelieve or not, not necessarily believe the the denial of consent. So the evidence of other witnesses, including the accused, about the totality of the complainant's conduct can be considered to determine whether that it is consistent with the complainant's claim of non-consent. So in this case, one of the accused, Carter Hart, testified, and the Crown introduced into the evidence the police statements of others, which contain exculpatory evidence. Accordingly, the court must apply the principles set out in WD. So we already went over WD and how it works. The court must not choose between competing versions of the events and decide whose version it prefers. In this case, there is potentially exculpatory evidence that was led by the Crown through their witnesses, as well that must be considered in the context of the whole of the evidence. It is absolutely a mistake of law to be like, I believe her more than I believe him. 100% a mistake of law, right? They have to at all times go with proof beyond a reasonable doubt. And they note the test is a reminder that the burden never shifts from the Crown to prove every element of the offense. So, carrying on a little bit here. It is incorrect to instruct a jury in a criminal case that, in order to render a verdict, They must decide whether they believe the defense evidence or the Crown's evidence. Putting this either-or proposition to the jury excludes the third alternative, namely that the jury, without believing the accused, after considering the accused evidence in the context of the evidence as a whole, may still have a reasonable doubt as to his guilt. And you know what the other thing is that the jury is entitled to go, I don't believe any of these fuckers. I have literally, I have quite literally on multiple occasions made my submissions as to, like, I went up at one point and I said to the court, I said, Your Honor, I don't know what happened here. And I submit that you don't either. And we have heard, I'm going to suggest, very little reliable evidence in this case. Every bit of evidence that we have heard is contradicted by another witness. Many of these witnesses have testified in a way that they are apparently sure of what they were testifying to, but they all contradict each other, and their credibility, the reliability is poor. I'm not even going to tell you, Your Honor, that you should believe my client, because I don't know if you should. But I will tell you that there is no basis to convict my client. And the judge at the end of it was just like, I believe that every single witness I heard in this case lied to me to some degree or another. And because of that, I must acquit the accused because Mr. Runkle's right. I don't know what happened here. So you're not wrong. You are not wrong. My client was a little pissed at me because he's like, what do you mean? I've had a few cases where my client was pissed because I said something that helped them, but that they didn't like. I had another case where I told the court that my client was stupid. I told the court that my client was really, really dumb. And my client wanted to argue with me, and he's like, no, I'm not. And I'm like, shut up, sir. I've got this. And he didn't like that I was saying that he was stupid, but he was, and it was helpful to his case that he was stupid because he was not capable of doing what the Crown thought he did. So, all right. Courts must be cautious in considering demeanor evidence and assessing credibility, particularly emotional upset when testifying, since emotional presentation can vary depending on many factors. That said, the lack of emotion might, Claude Simeon says, I'd hate you so much if you said in court that I was stupid. Oh my God. Sometimes it's true. Sometimes it's true. I'm sorry. Some clients are not smart. It just is. So, what is it? They set out certain principles that a judge should consider. So one of the most valuable means of assessing witness credibility is to examine the consistency between what the witness said in the witness box and what she has said on other occasions, whether or not under oath. Inconsistencies may emerge in a witness's testimony at trial or between their trial testimony and statements previously given. Inconsistencies may also emerge from things said differently at different times or from omitting to refer to certain events at one time while referring to them on other occasions. Inconsistencies vary in their nature and importance. Some are minor, some are not. Some concern material issues, others peripheral subjects. Where an inconsistency involves something material about which an honest witness is unlikely to be mistaken, the inconsistency may demonstrate a carelessness with the truth about which the trier of fact should be concerned. A trial judge giving reasons for judgment is neither under the obligation to review and resolve every inconsistency in a witness's evidence, nor respond to every argument advanced by counsel. That said, a trial judge should address and explain how she or he has resolved major inconsistencies in the evidence of material witnesses. And then the court is going to go on and talk about the use of myths and stereotypes. Myths and stereotypes are absolutely forbidden. So, when assessing the evidence of a complainant in relation to an allegation of sexual assault, the court must not resort to the use of myths and stereotypes. Myths and stereotypes have no place in our law and distort the truth-finding function of the court. For instance, it is a myth that if a complainant remained passive or failed to resist the accused's advance, either physically or verbally, by saying no, she must have consented to sexual activity. In the past, twin myth reasoning that a sexually active woman is more likely to have consented to the sexual activity that forms the subject matter of the charge and/or is less worthy of belief shifted the inquiry away from the alleged conduct of the accused and towards the moral character of the complainant. People react differently to events. There is no correct or standard way for a complainant to react to a sexual assault. So, yeah. I can also say, how do I put this? So the argument that used to be used and is no longer allowable in, in at all in criminal cases is, is basically slut shaming, to go like, this person is totally, this woman sleeps around. She slept with everybody. And so therefore, she probably consented to this sexual activity. And I'm like, this myth doesn't even make any sense to me. This myth has never made any sense to me. Because if you've got a woman who has slept with like every guy in town, unless she has come back and said, I have slept I falsely accused every guy in town of sexual assault. I'm like, if she slept with every guy in town and she's actually only accusing one guy of sexually assaulting her, that doesn't suggest to me that, it doesn't suggest to me that that allegation is more likely to be false. It makes no sense to me, I guess, is where I'm going with that. It's just bizarre. So, yeah. Well, apparently there is a correct way because fawning response is incorrect. But I do agree with the stereotypes myths rule. The thing is that there just may not be evidence, right? There just may not be, this is, the twin myths are basically akin to the rape shield sort of stuff. You're not going to be able to get in evidence of past sexual activity unless there's some actual relevance to it, which does not go to any of these myths. They used to be made of statements of the accused. So a statement made by an accused person to the police is evidence for and against its maker and cannot be used against a co-accused. This is important. The version of events given by one accused in his out-of-court statement cannot be used to assess the reliability of a different version of those events given by another accused out-of-court statement. Further, it is trite law to say that the court cannot use the pretrial silence of the accused as evidence of the consciousness of guilt. I.e., if you don't give a statement, that does not indicate that you're guilty. Sexual attitude evidence. So in the previous case, they addressed the issue of the use of sexual attitude evidence. That is evidence from a complainant in a sexual assault trial that they did not or would not have consented to certain activity because it would be inconsistent with their beliefs, attitudes, practices, and preferences. Even if a complainant cannot recall the sexual activity, this evidence is circumstantial evidence that can support an inference that they did not consent. This is the law. This is a correct statement of the law, but I will say that there is a risk to this because often these sexual attitudes evidence can also be motivation to lie, right? Let's say somebody is strictly religious of the religion of, I don't know, I'm trying to make one up here. They're a strict follower of sworditarianism, right? And sworditarianism says no sex whatsoever, right? Like sex is not allowable. And so, like under any circumstance, it doesn't matter if you've been married to them for like 30 years, no sex ever whatsoever. So, and they are like a devout sworditarian. They are like, they have been, they have been a sworditarian for like 30 years. They have, what do you call it? All of their friends are sworditarians. And, yeah. So, and yes, this is actually sort of a belief that was held by a group called the Shakers. And if you're wondering what happened to the Shakers, well, there aren't any Shakers anymore. So, anyway, they say like, this is strictly forbidden to have sex ever. Well, I'm going to guarantee that some people still have sex, right? Even though that is their religious belief. And so they're like, I am a strict sworditarian. We don't have any sex like ever. And so, but if you do have sex as a sworditarian, you probably don't want anybody to know about it. You probably want that to be, something that you keep secret. And so, that might be motivation to lie, right? Why would she lie about this encounter? Well, because she doesn't want to tell her fellow sworditarians that she got down, right? So you can see how that one goes both ways, right? You can see how that one can sort of cut in both directions. After talking about sworditarians, yes. Do I mean Quakers? No, I mean the Shakers. The Shakers have it's a very, it's an odd thing. And I see people saying that there's 3 of them. So, yeah. So the court goes on to say that this evidence must be approached with care while also avoiding myths and stereotypes. That discussion is at paragraphs 54 and 55. Here's the other problem. Is that if they testify to this, they actually might be putting their past sexual activity into potential evidence. So, like, let's say you've got somebody who says, like, in a criminal trial, I would never be able to, like, call evidence to say, this woman has slept with every guy who is in town, right? Not permitted unless there's some reason why that's relevant that doesn't go to the twin myths. But let's say the Crown instead indicates that she has told police that one of the reasons why you know that it's not consensual sex is because she would never sleep with anybody. And then it turns out that, in fact, that's not true. When she says, I would never have sex, it turns out that, in fact, she does all the time, right? This is the problem with all of this. If it was up to me, I would say that this kind of evidence would just be inadmissible. I would just say, nope, this is out, right? This is not relevant evidence at all. But it's not up to me. So I just think that this is an incredibly problematic area of evidence. What I would have done and so forth. And yeah. All right. Analysis. It is not the function of this court to make determinations about the morality or propriety of the conduct of any of the persons involved in these events. The sole function of this court is to determine whether the Crown has proven each of the charges against the accused beyond a reasonable doubt. The burden rests squarely on the Crown and does not shift. I.e., they're not saying that, they're not saying that any of this is appropriate, right? They're not saying that, what went down is okay. The court is like, we're just assessing whether this was proven. They also note from a case Niznik, although the slogan "Believe the Victim" has become popularized of late, it has no place in a criminal trial. To approach a trial with the assumption that the complainant is telling the truth is the equivalent of imposing a presumption of guilt on the person accused of sexual assault and then placing a burden on him to prove his innocence. That is antithetical to the fundamental principles of justice enshrined in our Constitution and the values underlying our free and democratic society. So the believe women hashtag is not how the courts make their decisions, ever, full stop. It is just not how the courts decide it. And yeah, this is the paragraph that got put into pretty much every newspaper about this case. And they put it in as if this was groundbreaking shit, right? They put it in as if this judge was totally going off totally just going off and doing their own thing here. And that's not how this is. This is the judge just repeating the obvious. This has been the law since 2017. It's not new law. A determination of whether the Crown has met its onus requires a consideration of the entirety of the evidence. The court can accept some, all, or none of a witness's evidence. The court must consider the case against each accused individually, but the Crown's case relies, for the most part, upon the evidence of the complainant that the various acts of sexual touching occurred and that she did not voluntarily consent to the sexual activity in question. Crown's position is that EM did not make an affirmative, voluntary choice to engage in sexual activity with any of the accused on June 19th. So assessing the evidence of EM. The Crown submits that the complainants gave a cogent and detailed version of the events and never wavered on the core evidence of her testimony, and that any inconsistencies in her evidence were minor, insignificant, and usually on peripheral issues. The evidence of the complainant that she did not consent to the sexual activity in question is a matter of credibility to be considered in light of all the evidence, including the evidence of other witnesses, to determine whether it's consistent with her claim of non-consent. So, issues relating to the credibility of the complainant. There are troubling aspects of the manner in which the complainant gave evidence. For example, there was an exchange in cross-examination by Mr. Brown on a relatively minor point, but the manner in which the complainant answered the question was telling. The complainant was asked why she testified in chief that she weighed 120 pounds when, after reviewing her medical records, she knew that when she was weighed by the nurse on June 22nd, 2018, she actually weighed 138 pounds. Right? So this is not a big deal, right? She's saying she was 20 pounds lighter than she is, or than she was. And she responded, because I know that's what I had estimated at the time. So, question. So you just said what you said at the time rather than telling the truth? And she says, I just knew that's what I had estimated, but now I know later on with the medical records, I knew that that's what I weighed. So I'm sorry, I'm not sure if I'm understanding the question. She's like, I said this because it's not true, but it's what I said before. It appears that in this answer that the complainant, rather than answering the question truthfully, chose to repeat what she'd said previously. It also causes the court concern that the complainant acknowledged that where she has gaps in her memory, she filled those gaps with assumptions. This causes concern in relation to the witness's credibility and her reliability. Basically, she's making shit up. When she doesn't know something, she makes it up. That's what it comes down. Everyone revises down 20 pounds. This is standard. I don't think that matters one way or another. Asking a woman her weight is pretty messed up. It's relevant in this case because she's saying she's so much smaller than these guys. And they're like, well, you're 140 pounds, right? So that's kind of the thing there. The complainant also gave a vague answer when it was suggested to her in cross-examination that it was easier for her to deny the deliberate choices she made on June 18th and 19th than to acknowledge the shame, guilt, and embarrassment about those choices. She did not deny the suggestion. And she said, I don't know, I'm kind of struggling to understand that. And went on to explain that she blames herself and that other people should be held accountable, but it was a combination of things. Now, I'm just going to say, if you ask me right now casually, what do I weigh? I'd probably say I weigh about 150. But if you asked me under oath, if you said, Mr. Runkle, you are now under oath, you've given the whole promise to, swear to tell the truth thing, and you said, what do I weigh? I'd say, I don't know. And the reason why I'd say I don't know is because I haven't weighed myself in a long time. And I'm kind of worried because I kind of suspect I've gotten fatter. And I haven't weighed myself. So I don't know. Like, I might be more than 150. I haven't weighed myself because, yeah. Maybe I need to get less fat, and I don't know. And you might say, Mr. Runkle, you're skinny. I'm like, I am outgrowing some of my shirts. So also, I'm out of shape in the sense that when I went to the bouncy castle, I got tuckered out real fast, right? Real fast. So carrying on, she did not deny the suggestion. She said, I don't know. I'm kind of struggling to understand that. And went on to explain that she blames herself and that other people should be held accountable, but it was a combination of things. When EM was asked in cross-examination by Mr. Brown how anyone would know that what she was telling them about what happened at Jack's bar was not the truth, if not for the surveillance videos, the complainant answered, I'm not sure how that's my issue. I said what I could recall. I gave them the details I could provide. I was doing my best in giving them that information. On several occasions, the complainant referred to her evidence as her truth rather than the truth, which seemingly blurs the line between what she believes to be true and what is objectively true. So carrying on, they talk about inconsistencies in the complainant's evidence. At trial, the complainant testified that the sexual contact with the accused in room 209, which occurred after the sexual activity she engaged in with Mr. McLeod alone, was not consensual. In cross-examination, she acknowledged that when she provided a statement to the police on August 31st, she said she believed that what occurred in that room was all okay in her mind. She was probably thinking, yeah, it's fine. She also acknowledged in cross-examination that what she said was her best guess about how she felt about the events in room 209 when she saw the consent videos. She testified, based on what I'm seeing in the video and where I'm saying okay, and I'm trying to understand why I'm saying that, that was my best guess. Yes, that's on this day. And that's your best effort to describe your internal feelings about the room 209 group events at the time of August? Yeah, so again, it's seeing that video and for the first time and trying to make sense of it as well. That's what I'm communicating to the officer. Yes. EM testified that she was feeling scared and fearful when she was in the hotel room, yet she did not mention her fear in any of the 3 statements she provided the police in 2018. The first mention of fear was in her statement of claim. She explained that she had not processed the fear yet. So the complainant testified that her fear caused her to follow the directions of the men in the room, to lay on the sheet on the floor and masturbate and moan. However, in 2018, she admitted in a statement to police that she was liking the attention a little bit at the beginning. When confronted with this inconsistency, she said she had no explanation for that, and at that point, she had not yet processed what happened. The complainant testified in chief that she was trying to sneak away from Mr. McLeod while at Jack's bar and that she felt uncomfortable when she was dancing with the players. However, the complainant acknowledged in cross-examination that she reported in her first police statement that she maybe liked the attention while she was getting at the bar. She also acknowledged that the videos from the dance floor at Jack's bar showed that outwardly it looked like she was enjoying the attention she was receiving on the dance floor, but in her mind, she was really drunk. The complainant testified that it would have been obvious that she was not consenting to the sexual activity in room 209 because she was crying and trying to leave. However, she also testified that she was crying because she was being laughed at or because of the comments the men were making. When confronted with the possibility she appeared to be consenting when she was engaged in the sexual activity, she testified, "It could have appeared I was consenting." When confronted with inconsistencies between her evidence at trial and her earlier statements, she had a tendency to blame others. For instance, she said that Detective Newton spoke over her and cut her off when he took her statements, so that impacted on her answers. She also blamed her civil lawyers for inconsistencies and failing to catch the errors contained in her July 2022 statement to Hockey Canada. Evidence that specifically contradicts the evidence of the complainant. So, some of the complainant's testimony in chief was proven to be wrong once compared with the video evidence. For instance, during examination in chief, EM was asked about the interaction she was having on the dance floor at Jack's bar with Mr. McLeod and the other players. The complainant testified that she felt uncomfortable and that Mr. McLeod took her hand and placed it on his crotch, as did others. In cross-examination, EM was shown a video from Exhibit 6, as well as a still photo taken from that video, and she acknowledged that the video clearly showed that she touched Mr. McLeod's genital area with her hand as she was dancing, and that Mr. McLeod did not guide her hand nor cause her to touch him. She explained that this was not something she recalled happening. There was no other video submitted showing Mr. McLeod or anyone else taking the complainant's hand and putting it on their crotch. The complainant agreed in cross-examination that she told police that once she met the players, they were encouraging her to drink more and get drunker. She testified in chief that the players bought 6 of the drinks she consumed at Jack's. She also testified that once she met the players, they bought all of her drinks. This evidence was not supported by the video evidence. The video from Jack's bar shows that EM purchased 8 drinks for herself. There is no video from any of the players purchasing any drinks for her, except a small glass of beer given to her by Mr. McLeod. EM testified, because it looks like small glasses are there, that's it. EM testified that she felt pressure to be with Mr. McLeod throughout the night and that the players separated her from her friends. She was shown video from Jack's bar that showed that throughout the night she spoke to a bouncer whom she identified as a friend from high school. She also had a long conversation with him at the end of the night prior to leaving the bar. She then returned to the dance floor and left the bar with Mr. McLeod shortly thereafter. EM was shown messages in cross-examination from her friend VH, who was looking for her at Jack's. When VH sent her a message asking if she wanted her to get you from the guy, EM said she was okay for now. VH then sent her 6 more messages and made an audio call that EM did not respond to, although she was observed on video looking at her phone. She remained with Mr. McLeod. So it appears that she's specifically ignoring her friend going, should I rescue you? She's like, nope. That evidence is inconsistent with her evidence that she was being separated from her friends. When confronted with this in cross-examination, she denied a suggestion that she intentionally separated herself from her friends. She also denied that she was texting with VH while at the bar, something that is captured on video, and she explained it by saying that counsel referred to as texting when she was using Facebook Messenger. The complainant testified that she tried to sneak away from Mr. McLeod while at Jack's bar, but he followed her even to the bathroom, and that ultimately she agreed to leave with him. It was suggested that there were many opportunities to get away from Mr. McLeod at the bar if she really wanted to do that. At the end of the night, just before she left the bar with Mr. McLeod, the complainant had a conversation with the bouncer that lasted about 7 minutes, and she could have sought his assistance, but did not. The complainant testified that when she arrived at the Delta Hotel with Mr. McLeod, she was completely out of it and did not know where she was, but the video shows that she exited the cab without difficulty, looked at her phone, waited for Mr. McLeod while he's talking to the cab driver, entered the hotel, and walked up the stairs without difficulty. The complainant testified that she was naked and on the bed when the first two men entered room 209, and that she walked to the bathroom naked. Both Taylor Radish and Boris Kachuk testified that the woman in room 209 was in bed and under the covers, and she did not get up naked and go to the bathroom. The complainant testified that when she exited the bathroom naked and laid on the bed sheet that had been put on the floor, that the men in the room were telling her what to do and telling her to touch herself. She denied suggestions that she was the one who was being sexually aggressive towards the men in room 209 and asking for sex. When it was put to her in cross-examination that she exited the bathroom naked and started masturbating and then was asking men to have sex with her, she said that she had no memory of saying anything, and it did not sound like the way she would usually speak. Tyler Steenbergen testified that the complainant came out of the bathroom and began masturbating and said, "Can one of you guys come over and fuck me?" Brett Howden testified that the complainant said, "Who wants to have sex with me?" Mr. Hart testified that the complainant said, "Somebody come fuck me." Mr. McLeod in his statement said that the complainant said, "No one is going to have sex with me. Guys are pussies." Mr. Fermenton said in his statement that EM said, "Is anyone going to bang me?" And Mr. Dubé said in his statement that the complainant said, "No one will bang me." Almost so, Mr. Steenbergen and Mr. Howden both testified that EM called the men in the room pussies when no one would agree to have sex with her. That term was used by both Mr. Dubé and Mr. McLeod in their statements. According to the evidence of EM, she wanted to leave the room, but the men would not let her, and they convinced her to stay. However, the evidence of Mr. Howden, which was read in from his statement of July 3rd, is that Mr. McLeod said to her, "Why are you even here?" and that it did not appear that she wanted to leave, even though she threatened to leave. So, all of these are problems for her estimate, or for her evidence. Issues with respect to the reliability of the evidence of the complainant. She testified that she did not remember the events of that evening continuously, but just remembered moments throughout the night. She agreed in cross-examination that she has gaps in her memory that make it hard to remember the events of those nights in a cohesive way. She acknowledged that when she first spoke to the police, she said she could only remember bits and pieces of the activity. She also agreed while testifying that she filled in the gaps in her memory or knowledge with assumptions. These are some examples of the gaps in the complainant's memory. She did not remember touching his groin while dancing with him at Jack's. Did not remember dancing with Mr. Howden and Mr. McLeod together until she was shown the video. Did not remember texting VH while she was at Jack's. Did not remember her conversation with the bouncer at the end of the night. Cannot recall any conversation with Mr. McLeod during the consensual sexual encounter, including what they discussed the use of a condom. She did not remember a gap of approximately 15 minutes of time between the time Mr. Radish and Mr. Kachuk left the room and other men entered, or what happened during that time. Cannot recall if she had any conversation with the men upon whom she was performing oral sex. She has missing memories of what was said to her and others about the terms on which she was willing to engage in sexual activity. She does not remember much of what she said when she was room in 209. She did not remember either of the two videos being recorded in 209. She did not remember having sex with Mr. McLeod in the shower at the end of the night until it was included in the statement of claim filed in 2022. So this is not saying that she's dishonest. This is saying that she can't remember things, right? That she's got problems with her testimony, right? That is a big, sort of issue there. Another way that the complainant apparently filled in gaps in her memory with assumptions is the manner in which she answered questions. For instance, she would say, "I feel that and she would speculate as opposed to remembering or knowing the answer to the question. This reflects an uncertainty of memory. And if you don't remember, the correct answer in any circumstances to say, "I don't remember that," right? I don't remember that. And it's fine to not remember things. It's not fine to make things up. So, although the complainant did not remember texting with VH while she was at Jack's, she testified that she did not reply to those messages because she was really drunk and dancing. The complainant agreed in cross-examination that she could have done flirty or suggestive things while on autopilot that she simply does not remember. She described acting and speaking without being fully present. Although EM had no memory of what she said while she was in room 209, when it was suggested that she was the sexual aggressor in this situation and trying to initiate sexual activity with the men, she testified that she did not recall asking for that, I feel I wasn't saying anything, or I really just have no memory of saying anything. Another point in cross-examination, when it was suggested that the complainant called the men pussies because they would not engage in sexual activity with her, she said, that doesn't even really sound like how I would usually speak. When it was suggested that with the disinhibition she was experiencing from the consumption of alcohol, she was doing things she wouldn't ordinarily do, she said, with how drunk I was and the comments I was hearing the men make about this girl being fucking crazy, maybe I was saying things like that. But I have no memory of that. I just know that's not how I would usually be acting. And if they could see that I was that out of my mind and acting that crazy, then I feel like they should have known better. And it's perfectly reasonable to say that they should have known better, that they maybe shouldn't have done this and that they shouldn't have anything. But that's not the legal standard, right? And there is sex that is abusive but still legal, if that makes sense. Yeah. Although she did not recall either of the two consent videos being filmed, she offered that Mr. McLeod was hounding her to say certain things on the video. And, this is an inconsistency because if she doesn't remember the video being made, how does she remember what's going on about the video, right? During cross-examination, when it was suggested to EM that she was not responding to questions, she said it was her time to stand up for herself and she wanted to respond to questions how she wanted to respond. The complainant's consumption of alcohol. So we're going to skip over this a little bit because she says that she was really drunk. The court finds that she was not as drunk as she says. Motive to fabricate. The defense submits that the complainant had a motive to fabricate. It is submitted that the complainant created a narrative to explain to her mother, who found her crying in the shower, how she spent a night drinking, left her friends behind, and left the bar to engage in sexual activity with a man who was not her boyfriend. Furthermore, she had to find an explanation to provide to her boyfriend that she was a victim and not an active participant in this group sexual activity. The complainant testified that her mother called the police without consulting her, and her mother's boyfriend called Hockey Canada. According to the complainant, although she told her boyfriend what happened, she did not provide him any details. She told him she was too drunk to consent. Furthermore, once the criminal investigation was closed, the complainant filed a civil claim and included an additional fact, namely that what happened caused her to experience terror and fear, something that she had not mentioned previously in the 3 statements that she'd given to the police in 2018. EM also agreed that at the end of the night, she was upset because she felt that Mr. McLeod acted like a jerk, asked her if she had STDs, and wanted her to leave. So, after EM and Mr. McLeod returned to the Delta Hotel, they proceeded to room 209. So these are the facts or findings that relate to charges. So they find that he sent the group chat saying, "Who wants to be in a 3-way quick?" And then sent the following text, 209 Mikey. Carter Hart sent a text saying, "I'm in." She accepts the evidence of Boris Kachuk and Taylor Radish that the complainant was under the covers and not sitting naked on the bed when they arrived. The earlier statement of Mr. Radish admitted into evidence, but the woman appeared quite normal. Mr. Kachuk testified that when he was in the room, Mr. McLeod asked him if he would like a gummer or oral sex. The statement was made in front of the complainant, who showed no negative reaction. When he was alone with the woman, after Mr. McLeod exited the room, Mr. Kachuk described the woman as flirty and playful. So, complainant gave inconsistent evidence about what she expected to happen after the consensual sexual activity was completed. In examination in chief, she testified that she expected to spend the night. Again, she had no memory of any discussions about that. In cross-examination, she said that she would have wanted to be going home. So did she want to spend the night or did she want to go home? It was suggested that she remain in the room because she was expecting the other men to enter and wanted to participate in sexual activity with the other men. She denied this suggestion. She says that it doesn't sound like something I would say, but the court notes how a person behaves when they're clear-headed and sober may not be the person or way a person behaves when they're disinhibited after consuming alcohol. So, according to EM, When she exited the bathroom naked and saw that there were other men in the room, she was surprised and scared. However, she did not retreat to the bathroom and put on her clothing. She walked into the room naked and laid on the bed sheet, which was already in the ground, and began to masturbate. She testified that she could not think clearly to make a choice at this point. According to the complainant, the men told her to do that. This evidence is disputed by other evidence called by the Crown. Tyler Steenbergen gave evidence that she did it on her own. And so the Crown urges the court to exercise caution in approaching the evidence of any of the players who participated in the group chat on June 26, 2018. The Crown suggests that the players concocted a narrative in that group chat that taints their evidence. The court says, I disagree with the characterization of the group chat. While the men who participated in the group chat were recounting their observations of what occurred in room 209, there is no basis upon which I can conclude that they did so for the purposes of concocting a false narrative of the events. At that point in time, they were concerned about an investigation by Hockey Canada. According to the text sent by Mr. McLeod, there was no ongoing police investigation because the complainant told the police that she did not want to pursue it and it was a mistake. This is consistent with the text exchange that took place between him and EM on June 20th, 2018. So, Mr. Rowden testified in the group chats he was trying to convey exactly what happened. He was expressing anger because he felt the complainant initiated all the sexual activity in the room. So Mr. Hart agreed in cross-examination that they were trying to get on the same page about what they would say to Hockey Canada. He texted late in the chat, honestly, boys, nobody did anything wrong. We got consent to anything that she did. She was the one begging for guys to bang her. In his text, Mr. McLeod reminded everyone to tell the truth and not to make anything up. Mr. Dubé told the group, let's not make her sound like too crazy, because if she gets wind of this, and then she can get even more angry, and we don't need that, so just be good about it, but the truth with it. In my view, the group chat reflects that the participants were expressing their honest recollections about what happened in room 209 and not concocting a false narrative. The evidence was that the participants have not had any further contact in the 7 years since that chat. It was suggested to the complainant that she was the one who was being sexually aggressive and asking for sexual contact in that hotel room. Various statements were put to her in cross-examination that were alleged to have been made by her. When she was asked in cross-examination whether she said certain specific things while she was in the room, for instance, someone come fuck me or you guys are pussies, EM often answered by saying that it did not sound like anything she would say. She did not deny saying those things. She also admitted that she could not remember much, if anything, of what she might have said when she was in room 209, and at points conceded that she may have said those things. This behavior made the men in the room feel uncomfortable. All right. So, let's sort of look here. And I'm just going to, yes, I am so demonetized and we're not hitting our goals. So it just is what it is. This is not my most successful stream, but that's not the point of it. The point of all of this is I kind of want to talk about this one because there's a lot of questions about it. This is an unusual situation in that there are witnesses to the sexual activity in question and what occurred immediately before it happened. That's very rare, right? It is very unusual that you have witnesses to sexual assault cases, right? It is very rare. And yeah, it is what it is. It's a necessary one. It's a good one for people to hear, but it's probably not one that are sort of a super chatty kind of thing. And also, thank you, Joe Loy. I saw your PayPal sending there. So, it's really rare that a sex assault has witnesses before and after, right? And during. So as I indicated, I accept the overwhelming evidence that EM was acting in a sexually forward manner when she was masturbating in a room full of men and asking them to have sex with her. This evidence alone does not establish her consent to engage in oral sex with Mr. Hart or anyone else, but it does establish that she communicated her willingness to engage in sexual activity. According to the evidence of the complainant, the men were telling her what they wanted to see her do, and they put her penises in her face, and she performed oral sex on 3 men. She could not recall what, if anything, the men said to her immediately before this took place. She could not identify any of the men. The complainant testified that she took on the persona of a porn star and that she was doing what she thought the men wanted her to do. She described being on autopilot. When she asked if any of the men on whom she performed oral sex spoke to her directly, she did not recall, and if they did, she wasn't really hearing it. EM's account of how the sexual contact began is unclear. According to the evidence of Mr. Hart, when he replied to the text sent by Mr. McLeod, he was open to the possibility of engaging in a sexual encounter. When the complainant was asking the men, "Can someone come fuck me?" he stepped forward. Although it was awkward, he also found it exciting. He testified that he did not want to engage in sexual intercourse in front of others and asked for oral sex by saying, "Can I get a blowy?" At that point, EM moved towards him and she agreed, saying, "Yeah," or "Sure." I have considered the totality of the evidence, including any words and actions of the complainant, in order to determine whether she did not consent to the sexual activity in question with Mr. Hart. They say the first consent video can also be considered by the court. Although I agree that it cannot be used to establish that the complainant consented to each sexual act that she engaged in my view, it is circumstantial evidence as to the manner in which she was behaving. The first video was taken without her knowledge, so it presumably depicts how she was behaving at the time. She was speaking normally, she was smiling, and did not appear to be upset or in distress. She did not appear to be intoxicated. The complainant can be seen rubbing her eyes, and she said that she may have been crying, but in my view, that evidence is speculation on her part, given that she has no memory of the recording being made or what was happening at the time. The incident of oral sex with Mr. Hart was brief, and it was ended by him. The Crown alleges that there was a second incident of oral sex that occurred after Mr. McLeod and Mr. Dubé received oral sex. Mr. Hart did not recall a second incident of oral sex, but only agreed in cross-examination that it was possible that it happened. The complainant only testified about a single incident of oral sex with the 3 men and then performing oral sex on Mr. McLeod. The Crown relies on the evidence of Mr. Howden, at least on this point, to support that there were 2 instances of oral sex with Mr. Hart. Based on all of the evidence, I cannot find beyond a reasonable doubt that there were 2 instances of oral sex with Mr. Hart. And note, they say the evidence of each of the witnesses has gaps and does not constitute a complete or sequential recounting of the events. For the reasons set out above, I have concerns regarding the credibility and reliability of the evidence of the complainant, and therefore I have a reasonable doubt about whether the complainant consented to the sexual activity with Mr. Hart. So, let's talk about this, because I've seen a ton of news stories saying that this court case found as a fact that she consented. And that is not what this says, right? It's not saying that they found that she consented. It's saying that they could not find beyond a reasonable doubt that she did not. Twixop says, and that right there is why this judge should be disbarred? Why? I don't see why. The court is not supposed to the court doesn't need to make any finding beyond just they have reasonable doubt. That's it. That's all. Was her consent vitiated by fear? And they note the question is not whether the complainant would have preferred not to engage in the sexual activity, but whether she believed herself to have only 2 choices, to comply or be harmed. If the complainant agrees to sexual activity solely because she honestly believes that she will otherwise suffer physical violence, the law deems an absence of consent, and the third component of the actus reus of sexual assault is established. So, she testified that in her mind, she did not want to be engaging in the sexual activity and did so because she had no other option. She testified that she did not know how the men would react if she said no or she tried to leave. She said that she was scared. The fact that there is no usual way for a person to respond to a sexual assault is well established in law. The court cannot and will not engage in stereotypical reasoning. The Crown suggests in their written submissions that science tells us that when a person is exposed to a threatening situation that causes extreme fear, stress, or a feeling that they cannot escape, the brain and body can flood with stress chemicals. No evidence was called in this case as to what science tells us about how people react to threatening situations. If you want to call science, you got to speak about science. In Hoggard, the Court of Appeal for Ontario found that the trial judge erred in admitting expert evidence of the effects of traumatic events on an individual. The court said that assessment of the credibility and reliability is the daily fare of judges and is grounded in common knowledge and experience. I must assess the claim by the complainant that any participation in the sexual activity was not because she voluntarily consented to it, but because she felt she had no other option due to her honestly held fear and that she would be harmed if she did not comply. The approach is subjective, but the plausibility of the fear is relevant to assessing the credibility of the claim. All right, so skipping ahead a little bit here, we're gonna, note here. They say the inconsistencies in the evidence of the complainant regarding her fear, along with the other evidence referred to, causes me to have a reasonable doubt about whether an honestly held fear was the reason for her participation in the sexual activity. Again, reasonable doubt, right? Reasonable doubt. And we're not going to go through the allegation or the things about everybody, but we will note, I am not satisfied beyond a reasonable doubt. On lack of consent or fear, with Mr. Footy or Foot, the Crown has not proven beyond a reasonable doubt that he had committed a sexual assault. With Mr. Dubé, court should find, based on the evidence, that he slapped her hard on the buttocks while she was on the bed performing oral sex with Mr. McLeod. So they say that he's also guilty of a sexual assault in relation to oral sex. Defense submits that the slap was playful and not the hard slap described by her that hurt and caused her to tell the men who were slapping her to stop. It was described as foreplay. Furthermore, the defense submits that it did not occur at the same time that sexual activity was taking place, and that the Crown has not established beyond a reasonable doubt that this constituted a sexual assault. In relation to the slap, she described in her evidence two separate events when slapping occurred. First occasion was relatively minor and did not hurt, but the second instance she describes as painful and involved a number of men who took turns trying to hit her as hard as they could while she was performing oral sex on Mr. McLeod. She says, while I accept that the slap took place, I do not accept that Mr. Dubé was one of several men who took turns slapping EM as hard as they could. As with the other sexual activity that forms the subject matter of the charge, the issue has always been not that each of the events happened, but rather proof of lack of consent. So the court notes, it would be wrong for me to parse out this one discrete slap from what I find to be a single, multifaceted period of sexual conduct. It would be wrong for me to find a lack of consent beyond a reasonable doubt for this application of force, which caused no bodily harm, embedded in this broader consensual conduct. As a result, I cannot separate the slap from my broader findings regarding participation of Dylan Dubé. So, in relation to the oral sex on Mr. Dubé, and according to his statement, after EM was on the ground and chirping them for not doing anything with her, he stepped forward to EM and pulled down his pants. She came up to him and began performing oral sex on him, which lasted only about 10 seconds. He knew it was a bad idea and did not want to be part of it, so he stumbled back. So, Crown finds, the court finds that the thing was not proven beyond a reasonable doubt. And we're going to see that for all of the other things, right? Not proven beyond a reasonable doubt. Not proven beyond a reasonable doubt. And so on every count, they are found not guilty, right? And now the court is not in the business of concluding whether consent happened or not. That is not the court's consideration. It's not how the court rolls. The court instead determines whether or not the lack of consent was proven beyond a reasonable doubt. Now, I will say, I think that this case is entirely in keeping with, with all of the prior Canadian case law. I will also note that I think that this case is tragic. And I think this case is tragic in part because the evidence on this one was very difficult for the Crown. Very, very difficult for the Crown to establish any sort of, to get to proof beyond a reasonable doubt here, right? It was very difficult. And I feel like the Crown, by pulling the witness into this and by making the witness, or by making the complainant go through this, actually probably caused more harm to the complainant than she would have otherwise. It also caused harm to the accused, right? And that's it, right? That is it. I think the fundamental problem with this judge is that they did not believe EM. And that is actually a determination that the judge is required to make, whether they find EM credible beyond a reasonable doubt. And so if the judge does not believe EM, then they are required to acquit in a case like this, like 100%. That's how courts work, right? That is how this works. Yeah. Did I mention what a jury would have found? I think a jury would have also acquitted. Do I think the Crown is going to appeal? I don't think so, but I can't say for certain. There's a couple of places where they could potentially find grounds to appeal, but so far we haven't heard anything about them like planning to appeal. They might have some ground to appeal with respect to Dubé and the slap, and we'll have to see. But I don't think that this is a good one to go for a retrial on. Like, I don't see it. I don't see that it makes a whole lot of sense. But let's go through super chats, and then we got more stuff to go through. We're 4 hours in, and I got more stuff that's on my docket, and I saw people wanting to talk about, so we're going to go through all of those. Phoenix Paw, I'm going to start off the super chats with a reminder that Ian has said he dislikes them. Just here to Streisand effect that to the fullest. Thank you, Phoenix Paw. Arctic Ginger says, hope you enjoyed Yellowknife. Sadly, I was off social media and had a migraine and was supposed to go to Folk. I'm sorry you didn't make it, because if you had, you would have seen me at the Folk festival there. So, yeah. Tom Horton, Ian, I saw your latest video. I fully support your suit against the government. The idea that only the Crown prosecutors can have access to first-hand firearms knowledge is absurd. Here's some cash for caffeine. You'll need it. You're not wrong. Panzer Dude, what could have been the punishment if they were convicted? 3 years and up. Start at 3 years and push it up from there. Daniel Bossard, go. Hot sauce, go. Tony P, spicy sauce makes the spice flow. Thank you. Phoenix Boss, second super chat, the horror to encourage Ian to test hot sauce. Count me in. Let the spice flow. Thank you. Donnie Not Wahlberg, member of 3 months. Heart. Thank you. Canadian Nico, hot sauce taste test support. Thank you. I feel like I'm probably going to see a subscriber decline at the end of this one, because it happens when you talk about difficult topics. But yeah. Canonical Heat, thank you for 20 gifted memberships. And I think I got to roll a this. Rainman, thank you for 10 gifted memberships. And Rainman says, my membership was butt dial, goal oriented. Thank you. Fiona W, thank you for 20 gifted memberships. David Craig, thank you for 10 gifted memberships. Deaver's Missing Integrity and Lapacetta's Disco Inferno. I'm just now realizing this happened about the time a particular adult website started running ads for a hockey-themed video. Eyebrow now very raised. I don't know about that one. Corey Cast reminds me of the guy who got his cylinder stuck in an M&M mini tube. How do you get it into the mini tube in the... that is something to never admit in public. Beaver's Missing Integrity and Laposetta's Disco Inferno. Does the Maker's Mark bottle have a flared base? Okay. Ian BPK. Any coffee besides a vanilla latte is unusual. Jamie F. Happy Monday. Thank you. Most used phrase tonight. I've seen that video. No rigid application necessary. Phrasing. Fair, but maybe not the case. Peyton Weismiller. Here for Runkle defending equality for women. Woo. This is a tough case. It's complicated. Pamela Wiesenbach for the sauce. Thank you. Laura Christine towards the goal. Thank you. Vomit Fountain. Let's get lost in the sauce with Runkle. Thank you. Kaisa94. Greetings from Norway. I've loved your videos on Proven among others. Thank you so much. I miss Norway. I've been to Norway. I haven't been there in a long time. But yeah. The KKF 1015. Thank you so much. Kate, maybe, really hope I don't know where this is going, but what happens if she's too drunk to consent? Is that really a Law and Order SVU type thing? Too drunk to consent is a thing, but you have to be quite drunk before that kicks in. The KKF 1015, give me less alcohol, but making me pay full price. I'd bet good money they water down their booze too. Yeah, I was like, this bar sucks. Rainman YKF, drink the hot sauce. Thank you. Deaver's Missing Integrity and Laposetta's Disco Inferno. BDSM, where no equals yes. Yes equals harder. Pineapple equals stop. There is case law to the effect in Canada that no matter what your safe word is, no is no. So, yeah. Tranquil Moments, thank you so much. Much appreciated. Deaver's Missing Integrity and Laposetta's Disco Inferno. We don't kink shame unless it's feet. Feet are weird. Jamie McMullen, thank you for the YouTube membership. I don't even kink shame feet unless you're doing weird shit around the feet. So, like, if it's consensual stuff, fine. If you are doing, like, non-consensual creepy shit around feet, then don't. H Scorpio, maybe no recording equals stringer bell rule. Maybe. Deaver's Missing Integrity, a whiff of it like a fart instead of a turd. I'm not sure what that was about, but that's concerning. Philip Coggins, just when I was beginning to see why they were acquitted, the second video comes up. Second video is not helpful to them, I don't think. Cindy Collins, happy Monday. Started mat leave today, due on Saturday. And Elf Wiggins, with you through all the demonetization. Yeah, this one is rough. M3, this was a tough one, and you did your best with it. I try. Celebrial 82 for the demonetization, and because you hate super chats. Thank you so much. I know I'm going to have offended some people, and I know, but it is what it is. This is a difficult case, and there is, that's the way it goes. We already know the position of the parties. Sometimes no, but I mean, yeah. M3 says, okay, hot sauce already. Thank you. Rick Daly 12, is it true the judge had to dismiss a jury here? Twice. The White Trash Panda, I didn't know elf lords kept pet dogs. Fascinating. My dogs are cute, but I think that they think I'm their pet, and not the other way around. Kyle Fox, we doing the Ian Samples Heatness Selection Challenge? I have done the, I've actually got a Hot Ones box sitting right there. Lady Fang, can't believe you've all been stuck with me for a whole year. Thanks, Runkle, for all your great content. It's still entertaining and informative. Thank you. Claude Simeon, my theory, her consent was violated, but due to extreme fawning trauma response, impossible to prove beyond a reasonable doubt. And that's a reasonable position to take, right? So Teaver says, see, I told you feet people are weird. Not all of them, just some of them. Crazy Cat Queen, if everyone is drunk, then how is anyone able to consent? Theoretically, it's possible to have a situation where both people offended against each other. Crazy Cat Queen, Ian, wouldn't it be weirder if someone climbed over a cubicle to get to someone's feet? I guess. Yes. Light Queen, all for the sauce. Thank you. Light Queen, still for the sauce. And to say goodnight all, have to be up at 4 a.m., so I need sleep. Fair. Phoenix Paw, here, take another super chat for the hot sauce. Thank you. Jamie F., thank you for covering hard cases. Thank you. David Craig, Bob caught some buckshot, but has no evidence. Number one forensic homeopath, Kimchi. How does the burden work with affirmative consent laws? Still pretty much the same burden. Boomer, Runkle, maybe do a maid stream sometime so people know the deets in Canada. I have done videos on maid issues. They get me a lot of hate mail. Catherine Fraser, thanks for addressing fun stuff and the tough. I mean, if I had like a brand manager, like if I had a person who sort of ran my stream and so forth, then I'm sure they would tell me to stay the fuck away from this case, right? But it's an important case in Canada. Geekbutt says, thanks for being a good noodle, Ian. You're genuinely greatly appreciated. Keep up the good work. Thank you so much. June Sidlauskas, Sharia law is advancing in Canada at national, provincial, and local levels. Not really. Is this law becoming more popular in Canada? It's not. Should it take precedence over current laws, the federal and state laws? Sharia law is not a thing in Canada. It's not, I don't know who's telling you that, but it's just not true. Sometimes there are people who agree to like deal with themselves in a Sharia law fashion, but that's just them agreeing to do business themselves in that capacity, which you can do for anything, but it doesn't take precedent over the court. You cannot, there are no like Sharia law courts. It's not a thing. So Giraffe Gal, thanks for not being afraid to cover these more difficult cases, Runkle. I will admit I'm a little afraid, but I do it anyway. BL, I will donate to your demonetization fund. The Hearts from Australia, thank you so much. Morgan says toward the demonetization fund, thank you. M3 towards your demonetization fund, thank you again. The Aurora H. White, thank you for your coverage of this case. In lighter news, your streams instantly calm my pups, so thunderstorms or when I catch up on what I missed. Oh, that is awesome. That is high praise. Thank you so much. Maybe not. Thank you for the 10 gifted memberships. Katie Hooling, thank you for 10 gifted memberships. And for the goal in the demonetization fund, if YouTube will allow it, keeps telling me I already own this. And bored at the wrong time. Welcome aboard. Thank you for the YouTube membership. All right. So let's I want to cover some of SIG Sauer. There's stuff I want to cover, and we as much as it's late, I want to cover some of this. So SIG Sauer makes guns. One of my guns, I actually own 2 SIG Sauers, believe it or not. I own a P320, and I also own a P320. I see a Hettinger saying I was hoping for locks. We can cover locks first. Okay. So to understand where we are with the Proven Industries thing, really it's ideal if you watch the previous video, because in the previous video I noted that Proven Industries is getting sued by Packlock. And the reason why they're getting sued by Packlock is that Packlock says that Proven Industries has been advertising all of their stuff as made in the USA, and that in fact it's not made in the USA. I'm being told I have to swoop, so we can swoop as well. What's a good swoop? This one has no music, but it is a good swoop. So that is a moose crossing the camera view. So they're being accused of saying all of our stuff is made in America when in fact it is made elsewhere. So Packlock is suing Proven Industries, basically saying we lost out on business because you lying about that stuff. So that is a big deal, right? And that is a huge issue. So there's that. One of the issues is that Proven Industries was accused of perjury because in the case of Proven Industries versus Trevor McNally, they said, well, all of our stuff is made in America. So now Proven Industries has filed an amendment. Moose, beautiful creature, but a heck of a lot meaner than people realize. I've got moose and bear on my property. I'm actually more worried about the moose than the bear, and it's not close, right? If something tries to take me out, it's probably more likely to be a moose. I understand that reference. So let's look at what just happened, because this is exceptional. So, notice of filing declarations to clarify record. So this is a big deal, because basically what this is they're saying, I want to amend things. And I see Shay B saying, let's reach the goal. And I think we're still 2 away. But so comes now plaintiff Proven Industries by and through the undersigned counsel, and hereby files this notice of filing declarations to clarify record, and states as follows. On June 2nd, certain declarations were filed in support of plaintiff's emergency motion for preliminary injunction, which was entered into the record in this case through the filing of the motion and relied upon at the hearing. Declaration of Ronald James Lee II in support of plaintiff's motion for emergency injunction and memorandum of law contains statements that require clarification and correction. Attached hereto as Exhibit A is a supplemental declaration of Ronald James Lee in support of his motion, which includes such clarification and correction. They also, the court advised the plaintiff to revisit the declaration of Anthony Sansone to clarify his relationship between Proven Industries and Dynamic Manufacturing Group. So attached as Exhibit B is a declaration on that. Okay, so let's go and look at that. And Shay, this is good. I promise my finances are good. That is fantastic, because I worry about people. All right, so this is Exhibit A, which we're going to embiggen because it needs to be big enough to read. Supplemental declaration. Whoop, now it's too far over. All right, there we go. Supplemental declaration of Ronald James Lee in support of plaintiff's emergency motion for preliminary injunction. And he says, on May 31st, I submitted a declaration in support of Proven's emergency motion for preliminary injunction and incorporated memorandum of law. In paragraph 2, I stated that all of our products are manufactured in the United States using high-grade materials. I am submitting this supplemental declaration to clarify that statement. The word all was inadvertently used. The accurate statement should have been almost all our products are manufactured in the United States using high-grade materials. The omission of the word almost was unintentional and the result of a drafting oversight. I submit this clarification voluntarily and in the interest of full transparency and accuracy. I want the court record to be clear and correct, even though the statement in question was not material to the issues presented in this case. Neither Proven nor I had any reason or incentive to misrepresent the origin of our products in this context. This case involved claims of copyright infringement, defamation by implication, false advertising, and violation of FDUPTA, arising from a video review of our product, not any dispute regarding country of origin or made in the USA labeling. The product origin statement was unrelated to the legal and factual issues before the court and did not impact the relief sought. I'm going to call partial bullshit on that, because they certainly mentioned that they're made in the USA because they wanted sympathy from the court, right? They wanted the court to be sympathetic from their view or to their position because they're a good old American company hiring Americans, supporting industry in America, and, eagle screech. That is really why you put that in there, right? And I mean, I can't fault them for that. I would have put that in too if it was true. Right? Like, if it was true, then you put that in there. But if it's not true, then maybe you leave it out. So, yeah, it's this is a bit of a problem, I think, and they're like, I am skeptical of this sub bit, right? Yeah. The misstatement was made in good faith and conferred no advantage to Proven or me in the litigation. This matter first came to my attention only recently. On July 18th, 2025, Pacific Lock Company, PacLock, filed a new lawsuit in the Middle District of Florida against Proven and me personally, alleging false advertising and false marking. Paragraph 27 of that complaint specifically references the May 31st declaration filed in this case. Upon reviewing that complaint on July 21st, I recognized the error and have filed this supplemental declaration promptly to correct the record. I was wondering how they'd weasel out on this, and this is how they're weaseling out on this, right? So, yeah. The facts stated herein are based on my personal knowledge. If called to testify, I could and would testify competently to these matters. I declare under penalty of perjury under the laws of the United States that the foregoing is true and correct. All right. That's the first one. And the second one is Sansone. Now, Sansone's issue is different. He's not talking about like lies and so forth. He's talking about whether or not he works for Proven. So he submits his third supplemental declaration to clarify my employment background and ongoing relationship with plaintiff Proven Industries. Now, keep in mind, this is all on a case where they dismissed this case. So I'm currently employed by Proven Industries with the title of Vice President of Manufacturing, primarily tasked with overseeing the daily operations of the manufacturing division, a separate company, Dynamic Manufacturing Group, LLC. For tax planning purposes, under the advisory guidance of Proven's accounting firm, there are several companies established by a single owner, each company serving its own unique role. These companies, each legally distinct and owned by the single owner, operate using a shared management team. While each entity maintains its own corporate structure, they function in a coordinated manner. Many of the resources utilized by each company are not interchangeable. However, the high-level management team, including the owner and myself, oversees the operation of all entities. In addition to my executive role at Dynamic Manufacturing, I also work with Proven Industries in technical consulting, high-level management, and engineering capacities. As the companies continue to grow, I act at the highest level of management, filling voids as needed across all organizations. In this role, I contribute to the design, testing, and evaluation of Proven's lock products, including the trailer hitch locks at issue in this matter. I also currently have an active role in Proven's customer service functions, where I act as the highest level of authority under the president and owner. Given my active involvement with Proven's engineering efforts, I am fully familiar with their products, their development, and the claims being asserted in this litigation, and I am qualified to offer observations and technical commentary regarding the same. Through my continuing work with Proven, I am closely involved in the design, evaluation, and testing of Proven's trailer hitch lock products, including the latch pin lock at issue in this case. I have firsthand knowledge of the engineering principles behind Proven's products and of the impact that the defendant's conduct has had on the company. As such, I make this declaration in support of the plaintiff's motion for preliminary injunction. So basically, it is just he's saying, yeah, this is how I work for Proven. This was much less important, overall. But it is funny to see the clarifications. All right. So we have hit our goals for the super chats. So we're going to roll this one. Come on, roll. There we go. All right, so the last hot sauce of the ones I bought in Vancouver is this one. Umami Bomb, shiitake chili oil. Plant-based, no preservatives, made in Canada, keto, noodles, spread, dip, stir fry. Ingredients. Number one ingredient is vegetable oil. Then tamari, white vinegar, shiitake mushrooms, tomato paste, black bean paste, salt, caramel, cornstarch, fermented soybean, chili peppers, spices, tahini, organic cane sugar. So this one is more of an umami flavoring than it is a hot sauce, but it's got an interesting consistency, and we're just going to try it right here. It's got a terrible color. It is very much brown. So it's not very spicy at all. It is very much a umami flavoring. But I'm going to tell you, the next time I make ramen noodles, like instant cheap ramen, I'm going to throw some of that in there, and I bet it's going to be amazing. So, yeah, that actually sounds fantastic. It's not very spicy. This is the hot, and I could barely detect the spice. Oh, and good night, Marmar. By the way, Marmar, the kayak is getting here soon. So, yes. All right, so let's cover. So I've got about 40 more pages of lawsuit. I think I'm just going to cover the lawsuit against SIG, and then we will cover SIG's lawsuit on another occasion or another video. So we're going to dive right in here. This is SIG getting sued. Now, the P320 is a gun. Pew, pew, pew. There have been a lot of allegations that the gun goes off on its own, which is an extremely bad feature for a gun, because a gun should not do that. A gun should only go off when you pull the trigger. And so P3 or SIG is being sued over this. Now, I should note, I do own a couple of SIGs. I own a P365, which is a prohibited firearm in Canada, but I own one because I've got the business firearms license. I did a whole video of that. And I also own a P226, which is like a 9mm handgun. Both of them are 9mm handguns, and I've never had no problems with the P226, and I've also had no problem with the P365, but the P320 has been alleged to be pretty problematic. Mrs. Squirrel, I would love to send you a selection from here. Every supermarket has a whole aisle of Sambal. I know what Sambal is. I love Sambal Ulek. Here. Yeah, I mean, I would be down. So, yeah. Really makes it hard to make the guns don't kill people, people kill people argument. Yeah, SIG is like, hold our beer. Hold our beer. David Shepard, good to see you. And yeah, they could collab with High Point. Maybe they could meet in the middle and come up with one that fires right. I mean, here's the thing. High Point, as much as they make inexpensive guns, they make guns that are pretty reliable, I think. Why is the P365 prohibited? The barrel length is too short for Canadian law. Canada requires a certain length of barrel, and the P365 is a tiny wee gun. So, yeah. All right. Plaintiff's original petition. Plaintiff Richard Fernandez Jr. Files his original petition against defendants SIG Sauer and CTC Gunworks, and respectfully shows the court the following. I am sorry, CD. It's a matter of like all the things. So yeah. Introduction. Officer Fernandez, an experienced senior police officer with the Houston Police Department, was shot on January 20th, 2025, while directing traffic for Martin Luther King Jr. Day community events. The reality that police officers put themselves in danger every single day comes as no surprise, but the circumstances surrounding this shooting are nothing short of shocking. Officer Fernandez's gun, our own gun, went off while fully holstered and without anyone ever pulling the trigger. There have been hundreds of other instances in which this particular gun, the SIG P320 semi-automatic pistol, goes off by itself, but SIG and CTC have failed to take the obvious and reasonable steps of either modifying the P320's defective design or at the very least warning the general public of its propensity to unintentionally discharge. As a result of these and other failures, Officer Fernandez suffered life-threatening injuries. And I'm just going to say that, in fact, SIG put out their own statement, and I'm just going to try to, I'm just going to pull this up. And so this was SIG's statement. By the way, SIG actually put this up with things saying it ends today because they're like, we're going to correct ourselves on all of this. So the truth about the SIG P320, this is from SIG. They say the P320 cannot, under any circumstances, discharge without a trigger pull. That is a fact. The allegations against the P320 are nothing more than individuals seeking to profit or avoid personal responsibility. By the way, if you don't think that this statement is going to be used against them at trial for the Fernandez thing, it absolutely will. Because if I am Officer Fernandez's counsel, I am totally tendering this shit. 100%. Recently, anti-gun groups, members of the mainstream media, trial attorneys, I guess that's me, and other uninformed and agenda-driven parties have launched attacks on one of SIG Sauer's most trusted, most tested, and most popular products, the P320 pistol. In all cases, these individuals have an ulterior motive behind their baseless allegations that the P320 can fire without a trigger pull. They have no evidence, no data, and no empirical testing to support any of their claims. They instead choose to misrepresent clear negligent discharges as a design problem. In the decades since its introduction, the P320 has undergone the most rigorous testing and evaluation of any firearm by military and law enforcement agencies around the world. It consistently delivers a proven record of performance and reliability through state-of-the-art engineering and documented quality control at every stage of its production. Claims that unintended discharges are anything more than negligent handling and/or manufactured lies to support an anti-gun, anti-SIG agenda are false. Furthermore, lawsuits claiming that the P320 is capable of firing without the trigger being pulled have been dismissed in courtrooms around the country. In addition, multiple plaintiffs, so-called experts, have conceded it is not possible for the P320 to discharge unless the trigger is fully actuated. Well, there's a guy on YouTube, and I'm not going to show his video, but it's something or other Gunworks. What was the name of it? Something Gunworks. Somebody in chat will be able to tell me. He did a video where he depressed the trigger slightly. Oh, Wyoming Gun Project. His video is excellent. He did a video, and by the way, for YouTube, this is an airsoft gun that I'm going to use as a demo. I can't find my clear airsoft gun, but I will note this is absolutely an airsoft gun, and I can demonstrate how it is an airsoft gun. So first demonstration of how this is airsoft is that it says on the side, Tokyo Mari, which is an airsoft manufacturer. Second demonstration is the barrel. You can see that inner barrel. This is an airsoft gun. So what they did in that demo is that they very much, they depressed the trigger slightly, and then they did this, like they gripped it, and it fires when they do that. Now, again, this is an airsoft gun, not a real gun. YouTube is going to freak out. Further indication that this is airsoft, you can see the air nozzle right there inside when it's held open. So, yeah, this is entirely not a functional firearm. Please do not strike because not a gun. So, what is it? the issue that it had is like when slightly depressed, if you do this, it fires. Now, one thing I will just note is that a lot of people have watched his videos and they've made the dumbest comment. And the dumb comment that they've made is they've said, "Oh, it looks like he's putting an empty case in the gun." And the thing is yes, he's putting an empty case in. And the reason why he's putting an empty case in is that it is not a cartridge. He's putting in a primed casing. And the reason why he's doing that is because he's doing this video like in his house or in his business or whatever else. And he doesn't want to put bullets through his wall. So he's just got a primer in there to show that it is actually, going off and that it would actually fire, but he's not actually putting in a live round because that would be freaking stupid, right? So, but anyway, that's the dumbest of the criticisms of that. So, yeah. All right. Whoop. So, also, for anybody who suggests that I'm here to support an anti-gun agenda, I am not anti-gun. I own a lot of guns. I, in fact, just put in an order for a submachine gun. So I am about as anti-gun or I am about as pro-gun as it's possible to get in Canada, right? Like, just full stop. I like guns. My whole career is, firearm lawyer and so forth. And and anti-SIG, I own 2 SIGs. Like, I own a P26. I love the P26. I own a P365. It's a great gun. But, so, if SIG is saying that this is like any discussion of this is to support an anti-gun, anti-SIG agenda, I am neither of those things, right? The rhetoric is high and we can no longer stay silent while lawsuits run their course and clickbait farming, engagement hacking grifters. Well, shit, not the first time I've been accused of being a grifter. Continue their campaign to hijack the truth for profit. Enough is enough. From the courts of law to the court of public opinion, we will combat the lies and misinformation with the truth. SIG Sauer stands behind the quality, safety, and design of all our products, especially the P320. Industry, take notice. What's happening today to SIG Sauer with the anti-gun mob and their lawfare tactics will happen tomorrow at another firearm manufacturer and then another. Today, for SIG Sauer, it ends. They're going to regret that if all of that comes out. Helen says, forgive my ignorance, do Canadian police carry firearms as routine? I'm in England. Yes, they do. Canadian police have a sidearm on their hip, and they probably have an AR in their car. So, it's a thing. All right, so let's what do you call it? Let's pull up our lawsuit again. So there we go. And then I got to stop this one. Stop screen. Share screen. Fernandez lawsuit. Here we go. And then I got to actually pull it up on thing. There we go. All right. So SIG is a leading designer and manufacturer of firearms. SIG's firearms are used by the U.S. military, law enforcement agencies all over the country, and hundreds of thousands of civilians through the state of Texas and the United States. I love SIG. I mean, SIG has some great, great guns. The P320 doesn't seem to be one of them, but lots of their guns are fantastic. Law enforcement agencies all over the country and hundreds of thousands of civilians throughout the state of Texas and the United States. Despite its popular and commercially successful status, SIG continues to market and sell fatally defective guns, both directly and through retail sellers, and it has done utterly nothing to recall the hundreds of thousands of defective P320 semi-automatic pistols since the P320 hit the market in 2014. Now, I would say, if Canada hadn't banned handgun transfers and made it really difficult to get handguns, I would have gone out and bought a P320. Like, I just would have. But I'm trying to get one. It's going to be a pain in the ass. Taurus is my preferred EDC. I mean, Taurus does not have a great reputation. If I could carry, I would probably carry the SIG P365. It's a great, great one there. So SIG's design of the P320 pistol is unreasonably dangerous for its intended uses. The weapon is defective because it unintentionally discharges when the user did not pull the trigger, or, as in this case, when the gun is holstered and the user is not even handling the gun at all. Instead of acknowledging the dangerous defects associated with this weapon, SIG and its sellers have doubled down, claiming there's nothing wrong with the P320's design, and any contention otherwise is simply anti-gun propaganda driven by the mainstream media and greedy trial attorneys. Ooh, it's me. I guess I'm greedy trial attorneys? Shay B, if you love the Taurus, then rock the Taurus. And if it's working for you, then fantastic. Knowing full well there are serious problems with this gun, SIG instead allows gun owners to play Russian roulette as to the next time the P320 will spontaneously discharge without anyone ever pulling the trigger. It has chosen to ignore the increasingly prevalent risk that P320's unintentional discharges will cause serious injury or death. Not only has SIG failed to acknowledge the P320's fatally defective design, but remarkably, it has continued to tout its safety. And then here we have safety without compromise. Safety isn't negotiable. The P320 maximizes peace of mind with a robust safety system, including both a striker safety and a disconnect safety. And because of its innovative 3-point takedown safety, never again will you need to pull the trigger to disassemble your pistol. I mean, that sounds great, but, if the thing goes off when you don't pull the trigger, then that's not ideal. Now, again, none of these allegations have been proven in court. This is all, as Emily would say, allegations and shade, but there are some pretty convincing videos out there, and yeah. SIG's website also includes a video which highlights the safety features of the P320. In it, SIG claims that the P320 will only fire once each of the following 5 events occur. So 5 steps required to fire a P320. 1, trigger is pressed to the rear, moving the trigger bar forward. 2, captive safety lever rotates upwards. 3, striker safety lock rotates upwards. 4, sear rotates downwards. 5, striker pin is released. This claim is demonstrably false because there have been hundreds of reported cases nationwide of the P320 discharging without the trigger ever being pulled, including this one. So, what is it? For instance, in November of 2022, 33 plaintiffs filed suit against SIG in the United States District Court for the District of New Hampshire, claiming that their P320s discharged without the trigger ever being pulled, just as it did here. In February of 2019, a class action lawsuit was also brought against SIG in the United States District Court for the Southern District of Texas. I'm getting tired. My brain is starting to fail. Which related to the P320's propensity to drop fire, i.e. inadvertently discharge a round of ammunition when the pistol was dropped on the ground. In that case, the original complaint references several instances when the P320 inadvertently discharged, including one, like here, the pistol remained fully holstered and was not dropped at all. The P320's propensity to go off by itself has also been widely reported in the press. And so they got a bunch of news articles. In response to the ever-growing number of incidents of the P320 unintentionally discharging, several law enforcement agencies and training academies across the country have banned further use of the P320, including the Dallas Police Department, the Marble Falls Police Department, the Milwaukee Police Department, the Washington State Criminal Justice Training Commission. They're getting sued. I'm not going to get to their lawsuit tonight because I am running out of gas. But we'll get to it. We will cover it. It's just right now I'm running out of gas, so it'll be for future. And various others. U.S. Department of Homeland Security has also recently prohibited U.S. Immigration and Customs Enforcement officers from carrying the P320 as their duty weapon. Given how controversial ICE officers are, I'm sure there's people who would rather they continue to do it. But that's, I guess that's getting into politics. I am sorry. So we'll move hastily on from the politics because, yeah, my bad. I'm dropping things that I don't want to drop. All right. Dropping things I don't want to drop and I don't want to lose it. So, all right. Feeling this mounting pressure, SIG's PR strategy imploded. On March 7th, 2025, it issued a blistering statement which wholly deflects any responsibility for the hundreds of instances in which the P320 has fired without a trigger pull. Remember how I said if I was their counsel, I would totally use that statement? Well, their counsel is totally using that statement. And I see Shay B saying this is almost as bad as High Point's. High Point's actually at this point, like High Point, I'm going to be controversial here. I actually think High Point is, I like High Point. And I ended up making this statement. So I ran into a guy. I was at the what do you call it? The Canadian, like the National Law Conference. And I ran into a guy who was from, I think, Arkansas, if I remember correctly. And he asked me what I thought about High Point. And I said, listen, High Point is one of the best. High Point is like the Second Amendment personified. And the reason why I think that is because High Point is like, you've got a right to have a firearm in the US, right? Not in Canada. And so, and High Point is like, well, that right isn't worth shit unless you can afford one, like unless you can actually buy a gun. So High Point is like, we're going to do a $200 gun and it's going to be a safe, reliable gun. And yeah, I don't hate High Point. I actually kind of think High Point is, you can go worse ways than High Point. So, all right, carrying on here. They wholly deflect any responsibility for the hundreds of instances in which the P320 is fired without a trigger pull, usually causing grave injuries to law enforcement officers, veterans, or other members of the pro-gun community, like it did in this case. This statement, titled "The Truth About the P320," reads in part, well, we just read that. We just read all that one. Since then, SIG has been the subject of ridicule amongst the online gun community. That's me. I'm doing the ridicule. I'm just doing the ridicule. Yeah. And since then, there have been even more instances of the P320 firing without a trigger pull. One incident occurred on April 25th, 2025 at the Achilles Heel Tactical Gun Range in Knoxville, Tennessee, and was captured on video. Pink, I don't have any issue with like you having a lawsuit. I don't know anything about your lawsuit. So I can't comment on it. But if you want me to like cover your lawsuit, shoot me an email, runkleofthebailey@gmail.com. And yeah, 100%, like I will look at it, but shoot me the email. Within days, Achilles Heel Tactical issued a statement banning further use of the P320 from its classes, training center, or training events due to the safety hazard the P320 poses. Another incident occurred on June 24th in Ceres, California, where a school resource officer was injured when her P320 remained holstered. Implicitly acknowledging the major problems with the P320's design, SIG recently and quietly revised the P320's operator manual, which now advises the most effective safety is to carry your pistol without a round in the chamber and to load a round in the chamber only when ready to fire. Yeah, fuck that shit. So this is what is called Israeli carry. Israeli carry is kind of dumb. So the idea of Israeli carry is that, and again, YouTube, this is airsoft. This is an airsoft gun. It cannot harm anybody. But basically, you've got the gun, and the chamber is here, right? And so there's no round in the chamber. And so the idea is that in the event of like a self-defense situation, you're going to pull your gun, you're going to rack the slide, and now you're good to go, right? Now you're good to go. Right? So, draw, rack, go. Well, that's way worse than just draw and go, right? Where you really want to be is draw, go. Especially because, let's say somebody is attacking you real close in, you might want to draw. You can't see it. You just can't see it. So, like, here's me standing up. You might want to draw and fire from here. Somebody's too close for you to put your hands up. So you just draw fire, right? And if you're doing that, you're not going to draw, shuffle, like, all of this is, yeah, it's dumb. So, I hate it. Despite claiming to be the chosen firearm for military and law enforcement agencies, SIG did not bother to issue any press release or public statement for how it now advises carrying the P320 without a round in the chamber. It should totally, yeah. I mean, if you can't carry it without a round in the chamber, it's unsafe. CTC has also touted itself as Houston's premier gun store, striving to serve the needs of law enforcement, military veterans, and first responders. CTC further promised to provide the very best equipment at the best possible price. Despite these assurances, CTC sold Officer Fernandez the defective P320 pistol that caused his severe injuries, when it should have warned unsuspecting law enforcement officers and individuals like him of the known and widely reported problems with this gun. By the way, I just want to note that little shout out here in the case from Brandon Herrera. Brandon Herrera gets a little shout out in the case. So yeah, that is pretty awesome. I got a voicemail from somebody and I don't know who it was. So yeah. I'm gonna have to check that later. We're not gonna check it now. Ooh, Battle for Alberta now open. August 9th. I might have to sign up for that as soon as I can, which is not right now, but we'll do that. Chat, remind me to sign up for Battle for Alberta. So yeah, Brandon Herrera is there. What ends today is SIG and its sellers' deflection of responsibility for continuing to put a product on the market that they know is defective and endangering lives. By the way, they're suing the gun store. They're suing not just the gun maker, but also the gun store. So parties. Fernandez is a resident of the state of Texas. SIG Sauer is a Delaware corporation, because of course it is. CTC Gunworks is a Texas company. All right. Jurisdiction and venue. They say Texas is the appropriate place. Cool. We're going to skip over that. He seeks monetary relief of over $10,000, or sorry, $10 million. Not 10,000, 10 million. Battle for Alberta, is that LARP? That is not LARP. That is a shooting competition. So, facts, history of the P320's defects. SIG's P320 pistol was first introduced in 2014 and received rave reviews from gun enthusiasts. For instance, in January 2017, it won the Modular Handgun System competition and earned a $580 million contract to supply service pistols to all branches of the U.S. military. But beginning in or around 2017, let's see, the reports the P320's unintentional discharges, whether from drop fires or from instances where, like here, the trigger was never pulled at all, began to surface. These early reports concluded that the pistol was defective because of the design of its trigger and sear. So, let me just see. Ooh. Oh, wait, am I already registered? I am already registered in P320 or in the Battle for Alberta. I just checked that. So, already registered. I'm going to squad in squad 1. There we go. There we go. It's an empty squad for now, but yeah. All right. The Army demanded a change in the design, and SIG obliged. SIG did not, however, implement a mandatory recall of its P320. Instead, on August 8th, it implemented the P320 Voluntary Upgrade Program, which was primarily implemented to ensure the pistol was drop safe. As set forth on its website, the no-cost voluntary upgrade program included an alternate design that reduces the physical weight of the trigger, sear, and striker, while additionally adding a mechanical disconnector. On its face, this is exactly what you should do, right? Is to add is to fix the problem, right? So fix the problem. On the upgrade problems, frequently asked questions, SIG answers the question of whether the P320 is safe in its current configuration. Yes, the P320 meets and exceeds all U.S. safety standards. However, mechanical safeties are designed to augment, not replace, safe handling practices. Careless and improper handling of any firearm can result in unintentional discharge. The FAQs explain that the reason for the upgrade is because a potential discharge of the firearm may result when dropped, although it is a rare occurrence and usually occurs after multiple drops at certain angles and conditions. SIG further confirms that an external manual safety will not be installed as part of the upgrade. These design upgrades were automatically added to the P320s manufactured after the initiation of the voluntary upgrade program in 2018, but SIG has never required the return of any defective P320 firearm. However, even after implementing these design changes, the unintentional discharges of the upgraded P320s kept occurring, even as here when the pistol is fully holstered, not dropped, and not being handled at all. On information and belief, the pertinent defects which SIG has failed to remedy include its extremely light trigger pull and the P320's lack of any external safeties, components which are commonly found in other duty pistols. So this airsoft gun has an external safety on it. So the airsoft gun has an external safety, which, yeah. When that's up, you can flip. You guys can't even see it. It is too tiny. So external safety right there. That is safe. It locks the slide. And when in safe, it will not fire. When in down, it fires. So, yeah. External safety. Not all guns have an external safety. My SIG P320 does not. And, yeah. I am going to bet that I'm not going to, without Ian McCullum's permission, I'm not going to share shit. I guess is the thing. I don't know if it's correct that he wouldn't care if I shared it. So, yeah. All right. Other design defects on information belief include, but are not limited to, SIG's design lacks a trigger safety capable of preventing unintentional discharges. SIG's design lacks an adequate internal safety mechanisms capable of preventing unintentional discharges. Adequate redundant safeties or similar devices capable of preventing unintentional discharges. Fails to prevent the movement of any internal components that would engage the P320's firing mechanism unless the trigger is first pulled. And they fails to use component parts of proper size, dimension, and weight so as to prevent unintentional discharges. I'm just going to say the external safety is like here. So this thing here is the external safety, but it's not the only safety on this airsoft gun. It's also got a grip safety. So when you hold the gun, you've got a grip safety. And again, airsoft gun, YouTube. So when I'm not holding the grip safety, I cannot pull that trigger. When I hold the grip safety, there it goes, right? So most modern guns have multiple safeties. What is a trigger safety? Trigger safety has a little separate sort of sub trigger that when you pull it, disengages safety features. So, all right. A defectively designed P320 shot Officer Fernandez on January 20th. So he's a 34-year veteran with the Houston Police Department. He's also a competitive rower and enjoys exercising and working out. As a former college athlete, he takes great pride in maintaining his physical fitness, both for his health and his job as a senior police officer. He purchased his SIG P320 pistol, subject handgun, from CTC. He was on patrol for a slab car event taking place in advance of the Martin Luther King Jr. Day Parade. He parked his patrol car in a middle lane on Airport Boulevard near the intersection of Martin Luther King Boulevard in an effort to divert traffic away from the Martin Luther King Day events. So he's just doing standard policing shit. After he parked and exited his vehicle, he walked to the passenger side door of another officer's patrol vehicle, which was also blocking lanes to divert the flow of traffic. While he exited the vehicle and walked the short distance to his partner's patrol vehicle, the handgun remained holstered. He did not touch the handgun at all. Within a minute of approaching the other officer's vehicle, Officer Fernandez was just about to start directing oncoming cars when he heard a muffled pop sound. Confused, he then started to feel warmth in his right leg. He looked down and, shocked, noticed a hole in his pant leg. Blood started pouring from his right leg and ankle. After other officers wrapped Officer Fernandez's leg with 3 tourniquets, he was rushed to the hospital via ambulance. The bullet from the subject handgun shot through Officer Fernandez's right calf and lodged into his ankle, but the subject handgun at all times remained holstered. He never pulled the trigger or otherwise handled the gun. The severity of his injury required emergency surgery to remove the bullet. He spent 3 days in the hospital, and he will require ongoing medical care for ongoing treatment, likely in the form of physical therapy. As a very experienced police officer, the unintentional discharge of his handgun has also caused him shame and embarrassment and anxiety, knowing that others may believe that he caused it to discharge. So, yeah. Cause of action. So strict liability for design defect. They're engaged in the business of manufacturing, designing, manufacturing, marketing, advertising, selling, and distributing firearms, including the subject handgun. They placed it on the market. They say they're defective and unreasonably dangerous because they function in a manner not reasonably expected by an ordinary consumer of firearms, including namely by discharging without any handling whatsoever. Defective because they designed it in a fashion that allows it to unintentionally discharge for all the reasons they stated above. Strict liability for manufacturing defect. So this is an alternative. They're saying, if it's if it's not if it's not a design defect, then it's a manufacturing defect, right? If it's not a shitty design, then you let a shitty gun leave your facility. So that's these are alternative arguments, but you always make the alternative argument because you don't want to lose, because they're like, well, you didn't argue that it could be could be this. So yeah. Deviated in its construction or quality from its specifications or planned output in a manner that rendered it unreasonably dangerous because it fires without pulling the trigger. Subject handgun reached Officer Fernandez without substantial change in its condition, i.e. it's not a result of any improvised gunsmithing, right? It's not like, hey, I tried to do it via gunsmithing, and yeah. Strict liability via marketing defect against SIG as a manufacturer. So risk of harm inherent in their pistols because they go off without pulling the trigger. They say it knew or it should have known that it will do that, and yet it failed to notify or warn him. So this is like, if it's not a design defect and it's not a manufacturing defect, and they're meant to go off like this and there's no problems with it, well, then you should have told me that I was buying a bomb, right? They're like, if this is like an unadvertised feature, then you should have warned me that I was gonna, that bad things were gonna happen. So, I mean, fair, right? Fair. Yeah, that's sort of their argument there, is basically, why didn't you tell me this thing's a bomb? And, and if you've watched Batman, the original, the 60s era Batman, you will know that some days you just can't get rid of a bomb. Whoop. Accidentally, there we go. Strict liability, design, manufacturing, and marketing defect. So CTC is in the business of distributing. So CTC is the gun store, and the allegation here is basically the gun store sold a shitty gun, and they should have known it's a shitty gun, right? And they say, in light of the numerous lawsuits and the widely reported instances of the P320 firing on its own, as Houston's premier gun store with expertise in selling firearms, particularly to law enforcement, CTC knew of the material defects associated with SIG's P320 pistols at the time it sold the subject handgun to Officer Fernandez. CTC knew, or in the exercise of ordinary care should have known, of its propensity to unintentionally discharge. Now, the thing is, if news gets out about this lawsuit, I very much suspect that we might see other gun stores being like, yeah, we're not selling this thing, right? We're just not selling it. Like, sorry, somebody else got sued for it. We're not suing one. Negligence and gross negligence. So they knew that it should or would be used and carried in the manner in which it was when it spontaneously discharged. Accordingly, it was foreseeable that ordinary users of the subject handgun, including law enforcement officers like Fernandez, would be harmed by it because of one or more of the unreasonably dangerous conditions present within the subject handgun, as outlined herein. It was also foreseeable that bystanders near the subject handgun would be catastrophically injured or killed by any unintentional discharge of it, including during use, handling, movement, assembly, disassembly, loading, or unloading, or as here, when it is holstered and carried. Such discharge was foreseeable to defendants as SIG had designed and manufactured the subject handgun in such a way as to prevent such unintentional discharges. SIG knowingly embarked on a marketing campaign which misled the general public as well as hundreds of thousands of end users, including Officer Fernandez, and it continues to do so. They say SIG misrepresented information to law enforcement agencies across the United States, misstating or omitting critical facts known to SIG. CTC further promoted SIG's misleading marketing campaign by failing to adequately warn the public of the risks associated with the P320, including the subject handgun. Ultimately, defendants' misleading marketing campaign discouraged end users like Officer Fernandez from searching out and/or selecting safer alternatives to the P320 pistol. Defendants had a duty to properly and adequately design, manufacture, assemble, test, inspect, label, provide adequate warnings, etc., and sell the handgun in a reasonably safe condition. So they breached his duties in all the ways they said before, permitting the subject handgun to be manufactured without one or more of the foregoing conditions rectified, failing to recall the subject handgun or to warn of the same, manufacturing it in an unreasonably dangerous and defective manner, failing to design it in such a way as to restrict, limit, or prevent the possibility of unintentional discharges, even in the event of inadequate or non-existent maintenance. Like, in theory, if you don't maintain a gun, it shouldn't go off on its own. It should just stop going off at all, right? It should just not happen. Improperly assembling, inspecting, and testing, and selling the subject handgun in such an unreasonably dangerous circumstance. All of the same stuff basically listed before. So, as a direct and proximate result, he was injured and suffered permanent injury, disability, disfigurement, scarring, pain and suffering, aggravation of pre-existing conditions, loss of past wages, loss of future earning capacity, mental anguish, loss of enjoyment of life, and medical expenses in the care of treatment of said injuries. All injuries are permanent within a reasonable degree of medical probability and will require further medical treatment. He will continue to suffer damages in the future. The above referenced breaches involved an extreme degree of risk considering the probability and magnitude of the potential harm. And so they say defendants had actual awareness of this risk but proceeded anyway. So they want actual and exemplary damages for past pain and mental anguish, future pain and mental anguish, past medical expenses, future medical expenses, past lost earnings, and pursuant to Texas Civil Practice and Remedies Code, they want an award of exemplary damages because they were grossly negligent. So basically all the money, we want $10 million. So, but they don't actually specify. They just say an above of 10 million. So they request a jury trial. And yeah, now I have not seen a statement of defense on this one yet. It looks like this was just filed. So I haven't seen a defense filed on this one yet, but I'm sure SIG will get a defense out soon. And so we will see SIG saying basically this, this is not true. This didn't happen. And yeah, I am sort of eager to see what what comes out of all of this. So yeah, I just don't know what's gonna happen here, but it's an interesting lawsuit. I wonder if Brandon Herrera knows that he's mentioned in it. So yeah. Bottle Shock. Hey Ian, better late than never. Absolutely. Good to see you, Bottle Shock. And yeah, we're just wrapping up. So this is a fun case. Now I'm going to wrap up here because it is midnight where I am and I have not eaten today. I should have some drumsticks that are ready to go. So that is my plan for right now. But we're going to read the super chats before we go. I almost forgot. Marmar, 29 months. Thanks for being an awesome human. Thank you so much, Marmar. Marmar has given me a kayak as well. Pink, I can hide your case. I can hide your name if you send me the transcript. CUB, you need to go on the unsubscribed podcast. I'd love to. They just got to invite me. So I don't know how that would happen. So there has not been, I have not been invited on the unsubscribed podcast as of this point. So yeah. Yeah, Marmar sent me a kayak. It's like an inflatable kayak, and I'm gonna go. I'm looking forward to putting that on the water there. That should be good. Shaby says, "Let's reach the goal." Thank you so much, Shaby. Honk Banana No says, "The little bit I can spare towards the demonetization fund." Thank you, Honk Banana No. Isaiah says, "Woot." Tranquil Moments, my EDC is a high point. Tranquil Moments says EDC is a high point. I mean, I actually kind of like high point. My EDC alternates between a Smith & Wesson M&P and a 60 DS Chiappa Rhino. I like the Chiappa Rhino, but I don't know if I could ever make it my... like, if I was allowed to carry, I don't think I'd make that my carry gun, because it's a revolver. It's a fun revolver. Born at the wrong time. I found many items that get a public stigma, have great value, and are perfectly fine. I don't buy things to impress people. I buy them because the item impressed me. You're not wrong. Julia 543, this is everybody's reminder to eat ice cream. I actually do have some ice cream in the fridge or freezer. And Belle Feinstein, thought of you when I was making sauerkraut with the fermenting kit from your Amazon link. Love the kit. I love it too. So yeah. Actually, what I'd probably... I might carry like a Rhino as like a backup, but not as a primary, I don't think. I love my Rhino too. I've got a Rhino. It's a great Rhino. It's a great gun. It's a lot of fun to shoot. I just don't know about it as a primary one. All right. So let's wrap this up. I will see you guys all soon. I'm hoping to tomorrow, hoping to drop an interview. And I'm also hoping to soon get a video out on some night vision questions. So good night, everybody. See you soon. And yeah, good night.